can be enough to constitute a habit. However, the Eighth Circuit, United States versus Jones, which is it's not Eighth Circuit, I take that back. It's a district court order from Judge Susan Richard Nelson. It's 96 Federal Rules of Evidence Service 1185 or 2015 Westlaw 927357. Notes that habit or pattern of conduct is never to be lightly established. It is only when examples offered to establish such pattern of conduct or behavior are numerous enough to base an inference of systematic conduct, the examples are admissible. Just so you know that I'm likely to deny, unless you have contrary to case law to that, and I don't think there is, I took a look.
Right.
I don't think you have enough of a numerous instances to constitute a pattern under Rule 406, so I think it's strictly a 404B analysis. So I'm going to ask Mr. Frank to come to the lectern and give his thoughts.
Good morning. Good morning, Your Honor. Thank you.
Right.
When this first came up back in September, we did file a memorandum with the court. I would ask the court to incorporate that into our arguments today. Following up on the court's most recent question, on page 21 of our memo, we discussed the habit claim, and we do cite a decision there from the Minnesota Court of Appeals referencing that it takes repeated conduct to establish a habit. I see no authority that...
Is it precedential?
It clearly is precedential.
Okay, thank you.
And time honored. It is a Court of Appeals decision, Hammer versus an insurance company from 1991. Again, it's 473 Northwest 2nd, 884 at page 891. I think the reliance, the attempted reliance on habit tells us a lot about the real motivations behind this. The desperation of the defense to just sort of smear Mr. Floyd's character by showing that, you know, what he struggled with, an opioid addiction like so many Americans do, is really just evidence of bad character. And that because he acted that way once before, it proves he acted this way in May of 2020 during a much different confrontation by Minneapolis police officers than the May of 2019 incident. But getting to the legal part of this first, this court knows 404B very well. You can't practice in this area very long without hearing ad nauseum about 404B. The appellate courts have told us very clearly the very first step in this process is to have the proponent of the evidence identify the precise fact that is of consequence to the determination. So what is it that is at issue in the case that is sought to be proved by this evidence? And that's what counsel is not doing here. Counsel is skipping that step and just simply going to, hey, these two things are similar, so it proves all these things that we should get brought in. We have to back up, as we argued in our previous memorandum to the court, and have the defense identify what it is they are seeking to prove.
Well, I think I could be wrong, and I don't want to speak for Mr. Nelson, but what I took from his argument here is that he's offering it to show that, for example, the white spot in the video is not gum or spit. It is, in fact, a pill, which is proven by what is found in Squad 320, but also his common scheme or plan of when he's approached by police, he immediately ingests drugs. And that's also relevant because it shows acute intoxication, which might lead to the death. Or do I speak incorrectly?
That's correct, Your Honor.
Okay.
So if that's the basis, and not absence of mistake, blaming his hypertension, but let's assume that's the issue.
Well, I think the hypertension comes in with the whole point of ingesting drugs immediately before arrest leads to the state or the defense. Part of the defense here is that they're saying it could have been a cause of death, and how do we know that it has a negative effect on his body is the May 2019 case where paramedic took blood pressure and his systolic blood pressure was over 200.
And let's not forget that in the May 2019 incident, the officers were concerned enough about his health that they sought medical attention for him. And they didn't force him someplace he didn't feel comfortable going immediately. They got him medical attention, and he survived. I don't understand how those two things are similar.
Well, the police response, I agree, may be dissimilar.
But I want to get back to, what are we trying to prove here?
Right.
What is the defense really offering this evidence for? Because all of this case law in 404B is about prosecutors saying one thing and trying to offer it for another way. Let's be frank about that, right? I mean, let's be candid. That's what
Well, you
this
can
is.
be.
Huh? Yeah, I know.
Bad joke.
Yeah, I usually let other people make that joke for me. But to be candid about it, right? So let's look at exactly what this is being offered to prove. If the fact that they're offering it to prove is that he ingested a controlled substance, and that the additional evidence since you made your previous ruling corroborates that, fine. But let's remember what evidence we already have of that, right? We do now have the search of the vehicle. And let me just sidestep for a second, because this discussion about the search of the two vehicles engages in a lot of hindsight. We have the benefit today of much more information than the BCA had at the time of the searches of those two vehicles. Those two vehicles, the initial search was done within days of this incident, which happened at night. The vehicles were searched not that day, but the next day, when what was mainly understood is that medical was called because of some injuries to the face. He was restrained by officers outside of the vehicle and died. It's not the typical, like, we arrested this guy for drugs. So the searches that were done with very little information.
And you don't have to justify the delay and all that. I'm just saying it was a little odd, but nevertheless.
I think I do, Your Honor, because in this context here, Mr. Nelson has brought this up and spoken about it at length. So I would ask the court's indulgence to let me explain that, because
absolutely.
I do think it's important. What they did is they conducted a search. They found blood evidence in Squad 320 that is Mr. Floyd's blood. That was the main focus of their search, because that's what they knew at the time. But what they also do, what a good forensic lab will do, is they freeze that situation. They photograph it completely, they tape it and seal it, and they store it in a secure storage, so that if there are questions later, more information comes to light, that can be done. And that's what happened here. And the pill fragments, I mean, I'm not going to second guess why those things weren't seen or recognized, but let's remember the very limited information that the BCA had when those first searches were done. But what they did right was preserve it, so we could find that out. So that's the additional information that you have today from what you had when you made your previous ruling about this. And what we know about Mr. Floyd, what we already have as evidence, is the toxicology report showing the presence of those substances in him. So why do we need to bring in this previous incident to show something that is quite attenuated? It is a different situation in that regard. So we already, as we argued in our previous memorandum, even if this is about whether he took a pill when the police confronted him, there is already evidence of that. And so if there is no need for this prior incident, which is prejudicial and could be used for improper purposes, when we have the evidence that we already have, that goes to the causation issues.
Well, and actually, in that regard, reverse Spiegel is somewhat different than Spiegel. When it's Spiegel evidence offered by the defense, as we often call reverse Spiegel under 404B. Again, the reason I read the Jones case was not actually for the habit. That was just something that was part of the analysis. But it was actually to note the survey of the different federal circuits. And Judge Nelson noted that a majority of circuit courts have held that 404B, which prohibits the admission of other acts as propensity evidence, does not apply if a defendant offers other act evidence of a third party to prove some fact relevant to his defense. And the third party here, of course, being Mr. Floyd. So I think, wouldn't you agree there's a different standard? Their bar is not as high when it's not offered against the defendant, not offered against a party.
I guess I disagree with that, Your Honor. 404B is a rule of evidence. It applies civil context, criminal context. We call it Spriegel evidence because of the Spriegel case, which was is really a case about notice before there were rules of criminal procedure. It was unfair that Mr. Spriegel had to respond to questions about his priors without notice. Well, clearly we have notice. But 404B is about other evidence that has, whose only potential probative value is propensity. And so propensity may be relevant, but we are very careful with 404B evidence because its propensity, its ability to prove by illegitimate means is so great compared to its limited probative value.
But the point being, when it's offered against a defendant, that defendant might be prejudiced in the jury's decision against that defendant, whereas when it's a third party, they're not a party to the lawsuit, and so the prejudice to them is kind of irrelevant. But anyway, I don't want to get off on that. I want to get more on the substance of why it would be admissible.
Yeah, and I understand, defendant's right to a fair trial, but it's a rule of evidence, and 403 is a rule of evidence, and the last step, of course, in 404B is the 404.3 balancing with a slightly different standard.
But isn't 403, when we talk about prejudice, it's prejudice to a party. It's not to a third party, not part of a lawsuit, except in this case, obviously, Mr. Floyd.
Well, I think it's prejudice to either case, right? I mean, it's the parties to the case, and we don't represent Mr. Floyd in the criminal case, but we have a case that we are trying to prove. It's prejudicial because it persuades by illegitimate means. That's what we generally define as prejudicial. Well, it's illegitimate in the eyes of the rules of evidence in a court of law.
That seems to be a little bit of a circular argument, but I'll let you go.
But I think that the concerns you're raising about criminal defendants are met by the additional safeguards we've put into 404B, although really, I frankly don't know why they don't apply to everybody. But that is to address sort of the heightened problems with criminal defendants and their rights, I suppose.
Right.
But it's still illegitimate means in the eyes of the law.
We've gone down a rabbit hole on this. Let's just go back to the substance of why it would be a 404B, a straight 404B analysis, yes or no.
And I do not understand how notice to Mr. Floyd is relevant to the issues in this case. Mr. Floyd had a history of hypertension, there's no doubt about that. But to say that he's on notice and so therefore he somehow gave up the right to be treated reasonably by police officers arresting him escapes me. The issues in this case are the objective reasonableness of the officer's conduct in the way they handled Mr. Floyd, whether he has hypertension, whether he's treating it, whether he is under the influence of a controlled substance, all of which the officers, well, not all of which, but the officers certainly suspected that. They all said that. Their duties as police officers, their conduct, can't take into account what happened in May of 2019. And I thought that that's what this court's ruling was based on previously.
Right.
It's simply irrelevant.
And let me agree with you on that point, because the statements made let's talk about the May 6, 2019. The statements made by Mr. Floyd to the paramedic seem to clearly fall under statements made for purpose of medical diagnosis. The paramedic was trying to figure out what his problem was. He was, to be honest, incoherent a great deal. Took the blood pressure found out what the blood pressure was. That is evidence of the effects of illicit drugs on Mr. Floyd. I think that's why it would be admissible. I agree with you, actually. The subsequent statement, you could have a stroke or heart attack, is probably being offered for the truth of the matter asserted. It is hearsay. If the paramedic comes in and talks about what the blood pressure was, that's appropriate. She's a fact witness as to what the blood pressure was at that time. And even could say, why did you take him down to the hospital? Because he was at risk of stroke or cardiac arrest. I think that makes sense if that witness is testifying. The statement to him in the videotape on the scene does not seem to fall under statements for purposes of medical diagnosis. Or I think that statement by the paramedic is probably not admissible. But everything up to that seems to be. Don't you agree?
Yeah.
If I allow it in.
This is a year before, and I quite frankly just don't know how it fits into an exception to this rule, how it relates to a fact and issue that we don't already know or don't already have evidence of. So in his 2019 incident, I mean, it's a year old, he is, how do we relate those two things between May of 2019 and May of 2020? And so what his blood pressure was on that day and the cause of that blood pressure and pulse, how do we possibly make that probative to May of 2020 and what was going on that day? It's simply so attenuated, whereas what is relevant is what the officers perceived with Mr. Floyd. And otherwise, to say he's on notice of hypertension, quite honestly, Your Honor, smacks of a superseding cause. And we're not going to get there, right? I mean, this is the classic eggshell skull, right? What these officers were dealing with is what they are responsible for. In your custody means in your care. They are responsible, and all the training that the jury will hear about tells these officers, you are responsible for this person. So what is relevant to this case is what they know at the scene at the time. Now,
well, that's relevant on intent and state of mind of the defendant. But I think as I understand the defense, they're offering this as proof of cause of death, that on May 6, 2019, acute ingestion of drugs results in a high blood pressure, hypertension, plus he apparently had a history of hypertension. Not that that matters whether he had notice of it or not, apparently he did, but I agree. It's not like that's relevant, but it's the whole point of he ingested drugs on May 6, 2019, which led almost immediately to a hypertensive emergency that the paramedic thought he should go to the hospital. So now, on May 25th, 2020, if he ingests drugs with that hypertensive condition, could that have caused the death? I mean, I think that's the only relevance I see. I agree with you on the officers. In fact, that's why I said I'm going to revisit Dr. Vincent's testimony. The officers have to deal with their person, their arrestee, as they find them, whether it's May 6, 2019 or May 25th, 2020. Emotional state feigned or emotional state genuine. Doesn't matter. They have to deal with the person as they present themselves and give them the appropriate treatment for what they see and what they know. And so the whole idea that his emotional response is the same on May 6th and May 25th, I agree. I'm not sure. I don't see really the relevance of that because but also goes to why then should we allow any psychiatric testimony from Dr. Vincent as to George Floyd's emotional state and the cause of it? Because the whole point is it doesn't matter. The officers are duty bound to deal with the arrestee as they find them, whether it's a feigned response or a genuine response. Doesn't matter.
And I'll go back to the sort of the classic concern that usually my friends on the other side are constantly arguing, and that is about the prejudice, right? I mean, you can go back, you can look at these cases for decades. The underlying problem is the probative value of some other evidence, when it is so slight, is just so far outweighed by the obvious prejudice of bringing in some other incident that is not at issue in the case. Even if there is some probativeness of this evidence to causation, this limited frame of evidence that you're talking about, it is far outweighed by the prejudicial nature, which you can just see from the arguments being made about just sheer propensity, right? That he uses drugs, there's a lot of drugs, he takes drugs, and
Don't feel sympathy for him because he's taking drugs? Is that kind of what you're...
I mean, that's,
I don't see that as what the defense is saying.
well, I think that's,
And if they tried to even argue that,
I
they'd
think,
get corrected very quickly from the
yeah,
court.
I think that's been the whole narrative that certainly, others of the defense in this case have worked very hard to get out there.
Well, and let me stop you there with, even with the propensity, I don't think propensity is appropriate in this case. And so if it was offered strictly for that, I would agree with you. You don't just, dirty up someone who has died in these circumstances as a defense. That would be improper use. I agree with you 100%. But to some extent, doesn't it also, I read in your reports that were part of the offer of proof, that there is a difference between a naive user of opiates and a chronic addicted user of opiates in regards to the effect that the opiates will have on them regarding overdose. A naive user, if you take fentanyl for the first time, it might kill you more readily than it would a chronic user. And to some extent, isn't the fact that he, a year before, admits and is using opiates, isn't that kind of relevant to your expert's opinion?
Could be. And Your Honor, I mean, obviously, as you've seen with this offer of proof, the treatment that Mr. Floyd received was basically monitoring him, right? He didn't require Narcan. He didn't require any type of emergency intervention. They monitored him, and he was okay. And he admitted to the officers that he had ingested a pill. Here, it appears he spit the pill out even. But tolerance is, obviously going to be an issue in this case. We're all familiar with tolerance, from alcohol. Most people have that experience. It's a little more complicated with fentanyl. That certainly will be covered. But the probative value of bringing in this other arrest in this other situation is so slight when the defense already has other evidence, and the state has as well, of these issues for causation, that it simply shouldn't be allowed.
And Mr. Frank, if we go back to let's go back to the actual language of 404B. It says that evidence of another crime, wrong, or act, it doesn't even have to be a prior bad act, or other act is admissible to prove the character, is not admissible to prove the character of a person in order to show action in conformity therewith. It may, however, be admissible for other purposes, such as, and then it goes on with our usual pigeonholed responses of motive, opportunity, lack of mistake or evidence. But it's actually a broader rule to say you can't use it for character evidence, but if you have another reason. Would you agree with that?
Absolutely, yep. The rule has a very good purpose, right? And we, in a court of law, we want the parties, we want the fact finder to focus on the facts of that particular incident and not to look at some other incident unless there is a connection of relevance between the two that's appropriate and not prejudicial. I always like to go back to Old Chief, the U.S. Supreme Court case that really talks about this as a sliding scale, right? What 404B recognizes is that evidence of some other crime, wrong, or act is potentially relevant, but you've got to explain why. It's got to be solid, and it's got to be for a proper purpose, not just propensity. Otherwise, the sliding scale of probativeness is just way down here at the bottom. And-
Let me touch on your prejudice concern. It sounds like from the state's questions during jury selection and the expert reports about chronic versus naive users of opiates, that even in the state's case in chief, there will be discussion of Mr. Floyd's challenge in dealing with drug addiction, that he was in fact addicted and he was trying and he was challenged by it. So the additional part of that he was found using drugs on May 6th, is the prejudicial value really that high vis-a-vis either your case or Mr. Floyd?
I think the prejudicial effect is exactly what Mr. Nelson has argued. It's his habit to take drugs and use drugs and fight with the police or disagree with the police and be agitated and crying. And that's the prejudice, is this police context to show bad character, right? I mean, that's the propensity. We use propensity as a substitute for character evidence. It's just a
Well,
bad
that
character.
also assumes that this is a on or off switch, that I let everything in from May 6th or nothing in. This can certainly be limited to what is probative and try and
Right.
keep purely prejudicial things off. But, okay, is there anything else you want to say? Because what I'm going to do, it's 5 to 9. I'm going to take it under advisement until tomorrow, at the very least. Mr. Nelson?
Your Honor, I do think, and I apologize, because again, this information continues to roll in. I do think that the interview of this witness that I just received as an FBI is also potentially probative to this analysis. In terms, again, the state seems to be conflating cause of death and the reasonableness of the use of force. I mean, there are two separate issues in this particular case. These particular pills, according to this witness, were different than anything else that they had previously used. So I think I would like to, again, supplement, and I'm glad the court, because this interview, I think, is highly relevant to that.
Is this the stuff you just received?
Yes.
Well, when did you receive? And I'm not faulting. I'm just saying, when did you receive it?
So this, my understanding is this was provided to the state on March 3rd. I believe it was mailed to me on the 6th, and I mean, I've been in trial, and so or selecting a jury.
Well, any objection to the court reviewing that as part of the offer of proof as to the 404B? All right, we'll receive that as an offer of proof for an in-camera review.
And with the caveat, now we're submitting something to the court without having the opportunity to address it. So
We'll talk about it again tomorrow.
very well.
I'll review it overnight. All right, so essentially we'll reserve further argument after I've had a chance to review that. So let's take a 10-minute break. Let's come back about 10 after, just so we can all readjust, get in place, and we'll check on whether our jurors are all here and whether they've all seen the video. All right, so we'll be in recess until 9:10. Sure. Are we ready? Oh, hold on, you're gonna make a record. All right, Mr. Nelson.
Thank you, Your Honor. Your Honor, yesterday, during the course of our hearings and proceedings yesterday, for purposes of the record, relevant to the request for a continuance, I neglected to reference the article I did in chambers later, but there was an article in the Washington Post that was published on March 12th of 2021, wherein the Washington Post reports that a Minneapolis official said the city had been concerned that this announcement could affect the trial. The official, who was not authorized to speak.
What was that?
Pardon?
What was that? Okay, go ahead.
Sorry. So I'll just restart, Your Honor. A Minneapolis official said the city was concerned that the announcement could affect the trial. The official, who was not authorized to speak publicly, said the city consulted with Hennepin County Chief District Judge Todrick Barnett, who told the city it could proceed. Barnett did not immediately respond to a request for comment. I think it's just simply for purposes of establishing the record relevant to the motions yesterday regarding the release of that information.
And I don't know if Judge Barnett is clarifying
I don't know
that is
either.
not an accurate statement. But I'm going to leave that to him and
Yes.
dealing with the media.
But in terms of any of the requests for relief yesterday, I do think it's a question of who made this decision to announce this. So.
And I think the bottom line is, this is a federal lawsuit. This court was not involved. And as I recall in my discussions with Judge Barnett, the answer was, we can't tell you what to do. And I think he expressed the concern that we would have about doing such a thing in the middle of jury selection. So there was no approval by this court. We had no authority to approve any release at this time.
I just simply am making a record.
I think the city is trying to try and dump their responsibility back in the court where it does not belong. Nevertheless, it is what it is, and we'll deal with it tomorrow.
Thank you.
All right, let's go with our first juror. Actually, it's the whole panel. That's right. Any seat, be just fine. All right. Now you can be seated. Well, good morning, everyone. First of all, can you all hear me? Give me a thumbs up if you can hear me. Okay, excellent. If you have any trouble hearing, we do have hearing assistance devices. My name is Pete Cahill, and I'm one of the judges of the district court, and you have been summoned as potential jurors in the case of the state of Minnesota versus Derek Chauvin, which is a criminal case related to the death of George Floyd on May 25th, 2020. A person charged with a crime has a right to a fair trial before an impartial judge and an impartial jury. In order to make sure that the jurors who are selected are impartial, the law provides that the court and the attorneys for the parties may ask questions to all the prospective jurors, which must be answered under oath. First, thank you for filling out and returning the questionnaire that was mailed to you. Your contribution to the important and serious matter at hand is best served by you continuing to provide full and complete answers to the questions that you will be asked today. Those questions will follow up on issues from the questionnaire and possibly other topics. Now, after the questioning is over, the attorneys will have the right to excuse some of you from service on this jury, and I may excuse others of you for what we call cause. In either case, it does not mean that you're not a fair person. You should not take offense in being excused. I also ask that you not take any offense at any question that you might be asked. We must pry, to some extent, in order to explore opinions you might hold and to hear about experiences that you have had that might affect your ability to serve in this case. The defendant, Mr. Chauvin, has been charged with murder in the second degree and manslaughter in the second degree. In the course of a normal trial, charges might be added or subtracted, but those are the charges as it stands. To the charges, the defendant has entered a plea of not guilty, which is a denial of each and every material allegation in the charges. I'm now going to have the participants introduce themselves, beginning with the state. Mr. Slisher.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Steve Slisher, representing the state of Minnesota.
Good morning. My name is Christina Aronakis, and I'm assisting with the prosecution.
Joshua Larson, also representing the state of Minnesota.
Good morning. Erin Eldridge for the state of Minnesota.
Mr. Nelson, if you'd introduce yourself and your client.
Good morning, ladies and gentlemen. My name is Eric Nelson. I'm assisted by my colleague, Amy Voss. We represent the defendant, Derek Chauvin.
Right. Does anybody recognize any of the parties who've just introduced themselves? That is, you're acquainted with them or have any kind of personal relationship with them? Okay, seeing no hands. Does anybody recognize anybody else in the courtroom? And again, not just recognize, but are you familiar with those people by way of acquaintance, friendship, work relationship? Okay, seeing no hands again. Does anybody know other people who work in the Minnesota Attorney General's office who might not be present today but might be present during trial, including Matthew Frank, Attorney General Keith Ellison, Jerry Blackwell, or anybody else who works at the Attorney General's office? Anybody have a relationship with somebody there? Okay, no hands. Anybody have any acquaintance or friendships or relationship with anybody in Mr. Nelson's law firm? Or have any dealings with his office? Okay. Now, you've been given a list of potential witnesses. Please review it before you are questioned individually. The question we will ask is whether you recognize anybody on that list. Now, one of the things the attorneys may not do during jury selection is to instruct you on the law. But I do want you to be aware of some of the basic concepts that apply in all criminal cases, so that you may keep them in mind as you answer the court's and the attorney's questions. So I will instruct you as follows. First, the charges against the defendant are not evidence, and they create no inference of guilt. No member of the jury should in any way permit himself or herself to be prejudiced against the defendant because a charge has been made against him or because he has been placed on trial. The defendant is presumed innocent of the charges made against him, and in order for you to find the defendant guilty, the state must prove guilt beyond a reasonable doubt. The defendant does not have to prove his innocence. The presumption of innocence remains with the defendant throughout the trial, unless and until he has been proven guilty beyond a reasonable doubt, according to the law and the evidence admitted at trial. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. Now, if you serve on this jury, you and your fellow jurors will be the sole judges of whether a witness is to be believed and of the weight to be given their testimony. There are no hard and fast rules to guide you in this respect, but in determining believability and weight of testimony, jurors may take into consideration the witness's interest or lack of interest in the outcome of the case, their relationship to the parties, their ability and opportunity to know, remember, and relate the facts, their manner, age and experience, frankness and sincerity, or the lack thereof, the reasonableness or the unreasonableness of their testimony in light of all the other evidence in the case, and any other factors that bear on believability and weight. If on this jury, you should rely in the last analysis upon your own experience, good judgment, and common sense. Now, there are things you should not do during jury selection. You are not investigators. You're not to go out and do any looking, and you are not to ask people about this matter. You are not to use the internet to look for information about this case or about the law. Above all, you must not talk to anyone who is involved in the case, the lawyers, the witnesses, or spectators. Do not be offended if the attorneys, parties, or witnesses do not speak to you. They know it would be improper to contact you except through the normal jury selection process, and generally they will confine themselves to a brief greeting. Now, during the selection process, your family and friends will be curious as to what you are doing. You may tell them you are on a panel of potential jurors in a criminal case, and that is all you should tell them. Since that is all you should tell family and friends, that is all you should tell the general public. So, during these proceedings, please refrain from using Facebook, Twitter, or other social media to announce that you are a potential juror or to comment on the trial. You may access those social media tools, but please do not publish any information about the case or your thoughts about the case. You do not have to stay away from people and refuse to speak to them. Do whatever you wish, but do not talk about this case, and do not talk at all to anyone involved in it. Now, because of the nature of the charges, this case is receiving media coverage. Do not read about this case in the newspapers or online, and do not listen to news about it on radio or television. In other words, affirmatively avoid reading or learning about this case. Now, this trial, including jury selection, is being televised, but no video of you or any other juror will be taken at any time, now or during trial if you are selected. Also, your name will not be used in the courtroom at any time. You will only be referred to by your random number to protect your privacy. The audio of anything you say will be broadcast unless we need to discuss something deeply personal or extremely sensitive or embarrassing or something that will specifically identify you. And in that case, I will specifically order that the audio not be broadcast outside this courtroom. In that case, you will still have to answer questions on the record, but without audio or video broadcast of any type. Now, with the exception of juror number 63, we're going to have you wait back in the other courtroom until it's your turn to be questioned, and you'll go with the deputy. But let me remind you, we are doing COVID precautions, so please keep social distancing, keep your mask on. I take my mask off only for this part so that you can hear me. When you're individually questioned, I'm going to put mine back on. But we have a lot of plexiglass, but we also have a lot of sanitizer and wipes. Feel free to use them in that courtroom and this courtroom. So with that, if you could go with the deputy, except for juror number 63. All right, juror 63, if you can come on up to the chair right next to me. And have a seat. And you are juror 63, is that correct?
Correct.
All right. A couple things. We have plexiglass in front of you and between us. I'm going to continue to wear my mask, and I've been vaccinated too, so hopefully that'll give you some assurance. And there's plexiglass in front of the attorneys when they ask you questions.
Awesome.
What that means is if you feel you could be heard better or would be more comfortable, you can take your mask off while you're being examined.
Awesome.
And totally up to you if you want to keep it on. I would ask in either case that you pull up to the microphone so that you're pretty close. It doesn't move very well. That's the unfortunate part.
Oh, very nice.
So if you could just do your best to keep your voice up, that would be appreciated.
Perfect.
And before I turn it over to the attorneys, a couple of questions that I have, but first I need to swear you in so that all of your answers are under oath.
Awesome.
So if you could raise your right hand. Do you swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. Well, first of all, you filled out a questionnaire, and thank you for doing that. It was a great help in getting all of us a lot of information about you to start with. Was everything true on that questionnaire?
Yes.
All right. Are there any changes or additions that you can think of at this moment?
Not that I can recall.
Okay. When the attorneys are asking you questions, it might prompt a memory, and I just want to tell you, it's okay to say something different than what's on the questionnaire.
Yeah, okay.
sometimes in reflection, this was a couple months ago, you realize I should have put this on, or that wasn't quite accurate, or maybe even your opinions have evolved. So you have absolute permission to give a different answer than what's on the questionnaire, because we understand the dynamic of this being written about 2 months ago. So you have heard something about this case, and you listed that there, but the questionnaire advised you not to read any more about it to avoid coverage. But we also understand that sometimes, because it was several months ago, inadvertently you may have been exposed to some information about the case. Maybe you saw a headline or a blurb on the news quick before you could kind of leave the room.
Yeah.
Or maybe even somebody was talking to you about the case and you're in the uncomfortable spot of, I can't tell you that I'm a potential juror.
Yeah.
A tough spot to be in. Any of those circumstances, we understand it's inadvertent. Have you received any new information about the case since when you filled out the questionnaire till today?
I think the only thing that was new that I had heard since I filled out was that drugs could have been involved in the case.
Okay.
I think that's the only thing new that I have heard since.
All right. Whether it's what you put in the questionnaire, heard before the questionnaire, or heard afterwards, do you think you could put all that aside? Because as a juror, the whole point is you have to decide this case just on the evidence and the law that I give you. Put aside what you heard outside the courtroom. Put aside any even opinions you had formed about the evidence. Do you think you could do that?
I believe so. I think that's the objective of any juror to do. I'm a very neutral person, I'd say, but yeah, I'd say that.
Okay.
I don't know much, so putting aside what I do know,
Okay.
I believe I could do that.
And I'm sure the attorneys will follow up a little more on that.
Yeah.
Are there any other facts that you may have been exposed to, not just about the core of the case, but maybe about pretrial matters, about related cases or litigation or anything like that, that might be important for us to know?
I do not believe so. Not that I can think of at the moment.
And I'm sure, like I said, if
Yeah.
a specific question prompts.
If I think of something, yeah, for sure. Let you
Okay.
guys know.
Do you recognize any witnesses on the list that you were given?
I did not.
Okay. The trial is going to be 4 weeks long, starting on March 29th. Can you make that work as far as your personal life, the timing, and the amount of time that has to be spent?
So I've recently, since I filled out that questionnaire, did get a job as a teacher.
Okay.
I'm a substitute teacher filling in for a person on maternity leave.
Okay.
So I think that would be almost a conflicting thing. They'd have to find a new substitute for that position.
Okay. But assuming they can do that.
Yes,
can you-
assuming that they can find a new sub and everything there. I don't believe I have anything else that would interfere.
Okay. I'm going to turn over to the attorneys, but a couple things. We've been talking like in a normal conversation.
Mm-hmm.
And in normal conversations, there are affirmations like that.
Yeah.
There are to indicate yes or no. We have to be a little more formal here, only because the court reporter is making a record.
Right.
And so we need yes and no, and we need for people not to talk over each other. So if you could wait till the question is asked and then answer. It's not a normal conversational style. We grant that. So just do your best on that. To be honest, the lawyers and I are the worst offenders on that, not the jurors. So just do your best on that. So with that, with regard to juror number 63, Mr. Nelson, you may inquire.
Thank you, Your Honor.
Morning, ma'am.
Good morning.
Your Honor, I was looking at some other information. Did you advise regarding the mask?
She can take it off if she wishes.
Right. Okay.
Leaving it to her.
Okay. I don't remember if you. I apologize. I was not listening to you. Perhaps I shouldn't admit that. Okay. Sorry about that, ma'am. Thank you for being here for us today. I appreciate your patience this morning. What I'd like to do is ask you a series of questions, kind of just get to know you a little bit better, and then ultimately ask you some questions about your questionnaire, your responses to the questionnaire. Not trying to trick you. We understand it was a long time ago you wrote it, and I'll actually probably read you your responses if that's okay. All right?
Sure, of course.
So my first question is, let's assume you and I were to meet in a different social circumstance, a party, an event, or whatever. What are a few things I'd learn about you during the course of that conversation?
I think you'd learn that I'm a very, I'd say, an outgoing person, charismatic. You'd probably hear that I'm a teacher. I love working with kids. I think, I don't know, I'm just a very outgoing, open person.
Okay.
Easygoing.
Sounds good. And I understand that you have your recent college grad, and you said you just got your first job?
Yes, correct.
Okay. I'll come back to that a little bit later in terms of the timing of the trial and stuff.
For sure.
But congratulations.
Thank you.
So at some point you received this questionnaire and you learned that you were a potential juror in this case. What was your reaction to that?
I was very shocked. I remember receiving the packet and thinking of any other case that it could have been, just some minor case, very unknown to the public. And then I opened it up and I saw what it was, and I was just very just shocked at first, in disbelief. I mean, it's the first time I've ever been called to jury duty, so it was just crazy to me that this was a case that could have been. I was a little worried about it because of how much coverage there is on it, how widespread it is and well known, and everything that has come of it. It made me a little bit worried just for, the safety, and I know that everything's not made public about the jurors and whatnot, but it still made me feel just a little slightly worried, just because you can never be too cautious or too safe in circumstances like this.
Well, let me ask you, so when you came down to the government center this morning and you saw all the fortifications and army and whatever else is going on outside, how did that make you feel in terms of your concerns for your safety?
Kind of mixed, I would say. I think it made me feel very safe that I was around all the security, but also a little worried that there's so much security needed for a situation like this. So it was a little bit mixed feelings about coming into so much security, I guess I would say.
Sure. Now, ultimately, when the judge was just introducing everyone in the case this morning, he informed you that obviously we're taking efforts to protect your anonymity. We're not televising your name or your face. But at some point in the future, it is entirely possible that your name would be known or would become public. How does that make you feel?
It's kind of hard to tell because I think it all depends on how the case almost plays out. It's a little nerve-wracking, I'd say, just because, again, it's a very controversial topic. Both sides feel very strongly, I would say, from what I know. And it can play out one or two ways. And there are people that will be happy, there are people that won't be happy. So I'd say it's a little nerve-wracking to think about. I feel safe, but it's just, you never know what's going to happen in the future.
Sure. Okay. So thinking about your personal life or your professional life and any of the positions you've ever held, can you think of a situation where you were called upon to resolve a conflict between two people?
Gotta think of a time. I would say in large scale, there hasn't been a time where I've had to do it for a major event, but there has
Sure.
been little times.
Like you may have two friends that are in conflict with each
Yeah.
other, right?
Yeah.
So how do you, and both of these friends come to you, right? And they voice their opinions or whatever this conflict is. How do you approach that situation? Meaning, like, how do you try to resolve that conflict between two people?
I think, like in any situation, it depends on who you, well, I guess in saying that we know both people equally, the facts that they present, you have to make them feel comfortable, listen to what they have to say, take in account what they're saying, and then for me, talking through it with them, I refer back to times in college when this has happened, and it's just kind of, for me, when these situations have happened, being there for the people that have brought this situation to me, and just listening and talking it through with them. Really, sometimes it was hard because there was bias. I maybe was included in the events, but trying your hardest if it's something that's mainly between the two to listen to the people and help them work through it and everything that they had to say.
Okay. So, I mean, ultimately you understand that your role of a juror, or the role of a juror, is there's large-scale conflict. Obviously, the state has brought criminal charges against Mr. Chauvin, and part of your job, or your primary job, is to resolve that conflict, right? But within the jury room, there would be 12 other or 11 other jurors, 12 total, and conflict may emerge amongst jurors. How do you think, if you were in the jury room and you were part of this case, and there's a particular piece of evidence that comes to light during the course of the trial, and some jurors are looking at that evidence saying, this is the most important piece of evidence, and other jurors are saying, no, this isn't. How do you approach the conflict in that context?
In context like that, I would say, I mean, each person has an opinion. Each person believes that something's important, more important than the other. You really have to listen to what everyone has to say, what they say about that piece of evidence, hear out why they think it's so important, why might they not think it's as important, ask the other people what evidence they think is more important than the one being presented by the other juror, and really listen to everything that each person has to say, take in account what they say. And I mean, we're all forming our own opinions, listening to what has to be presented, so you have to listen to what they have to say while correlating it to what you have thought of and what you have formed opinions about throughout the process.
And what other information may be presented, right?
Correct.
So what I hear you saying, and correct me if I'm wrong, is you have to listen to both sides and compare that with other information and compare that with your own formulations. Would that be correct?
Correct.
Now, you understand that your role as a juror, or your job as a juror, is to base your decision on the evidence that is presented in court alone. Do you understand that?
Correct.
And you can do that?
Yes.
Okay. Well, let me ask you this. Can you think of a situation in your personal life where you have been asked to resolve or determine if someone is lying about something?
I don't know if I've ever been asked to determine that. I think that's always just been something that, I mean, each person has done on their own, based off of how somebody's acting, how somebody is talking about something, up to your own interpretation about whether or not somebody's lying, because you truly don't know unless you're that person.
Well, let me ask you as a school teacher, right? You may, and I don't know what age group you come or you teach, excuse me, but you have two kids who come to you, and Timmy says this happened, and Jenny says this happened, right? How do you determine which of the two is telling the truth about that situation?
Yeah, in a situation like that, I don't really take sides. I just kind of play it off as if both people are telling me the truth, but I have to resolve the situation and make them both feel as if what they're saying is being heard, and find a way to find common ground.
Okay. Ultimately in a trial, you may have two witnesses who are perceiving the same event, right? They're looking at the same piece of evidence, and they may ascribe a certain meaning to that, or they may perceive it differently. So if you have two witnesses that are perceiving the same event at the same time, but they assign a different meaning to that event, or they interpret it differently, how do you resolve that type of conflict?
That is a good question. I would say, again, you truly don't know who's telling the truth, or even if they're lying, because again, like you said, they could be perceiving the situation in a different way, but in the way that they saw it. Again, I think taking in everything that each person says, and then matching, or I guess after, when you have time, thinking about what they said and how it correlates with everything else that we've heard, everything else that has been presented to us, because you have to assume that everyone's telling the truth or under oath, that what they present is correct, and really seeing how things align with the rest of the facts that are being presented.
Good. All right. Can you think of a situation in your life where you were 100% convinced that you were right, and then you later learned that you were wrong?
No, that's happened plenty of times.
And how do you how do you respond to that type of situation?
You feel embarrassed when it happens. Depending on the situation, apologizing to whomever you've had that situation with, and then thinking about where the miscommunication in my head might have gone that allowed me to think that I was right when I wasn't, to better understand the person who was right or the other side that was correct.
Okay. Now, ultimately, again, the judge has told you, and I've referenced that you have to decide this case on the facts. That's your job as a judge of the facts, right? That's what jurors do, is to judge what happened in this particular case. And at the end of the case, the judge will give you the law that you need to decide, right? Do you think that you can listen to the law and follow the law even if you think the law is different or should be changed?
I believe so. I mean, following the law is something that I stand by very firmly, and so if it's the law, I believe it's something that you should be following.
Okay. I mean, so if, as the judge tells you, this is the law of this that applies to this particular case, and you think in your mind, law should really be different, that doesn't make sense, can you still follow the law as the judge gives it to you, even if you think it should be changed?
Yes.
So I am going to follow up with some questions specific to your questionnaire. But before I do that, I just kind of wanted to inquire further about your job and things of that nature. So at the time you filled this out, you were looking for a job, right?
Correct.
And you have since found a job in your field of study, and it would require you're a long-term sub, basically, right?
Correct.
And how long, I mean, just generally, have you been in that role a couple of days, a couple of weeks, or did you get the job, a couple months ago?
So I got the job in January, but they recently had somebody leave, and so they switched me from my substitute position just around the school to this long-term sub in the last week.
Okay. And so ultimately, I mean, this is the question is, you would need to find a sub to replace you, or the school would, right?
Correct.
Is that something you're willing to do? I mean, how does that affect you financially, professionally?
Right. I think financially it's a struggle just because that money that I'm earning is helping me towards debt and whatnot. I don't know how easy it would be for them to find a replacement as well because teachers are so scarce right now, especially during the pandemic. And I know they were looking for somebody for this position for a while, and then they just switched me into it because they couldn't find anybody. They didn't want to, because I was the building sub. They didn't want to switch me into it, but they had to. So I don't know how easy it would be for somebody to take over that position necessarily. Those are my only concerns, I would say.
Okay. I guess in terms of understanding that jury service is a hardship for everyone,
Yes.
right? Would you be concerned that you're not going to be able to find a job after jury service, or concerned about the students?
I would say I don't know if I'm so concerned about finding a job afterwards. I think it's always a good lead to be in a job in a district, and then from there take on a full-time teacher role. I'm not sure if being away from this scares me so much from that being a possibility. It might be a possibility that it would prevent me, but I don't know necessarily if it would. I just know that if they do not find another long-term sub, the inconsistency of having a different person every day for the kids could be a struggle, especially because the class that it is has some students who need consistency. But those are my only concerns, I would say, so far.
Okay. Are you willing to set that aside, those concerns aside, and be a juror in this case? Or are the concerns so significant that it even is affecting your willingness to be here?
That's a loaded question in a sense that I have thought so much about it, and I am just at such a standstill with how I feel, because I believe it's the civic duty of everyone to do jury duty if they get selected, if they're called, but it's also so important to be with the students, especially during this year where it's been so crazy for them. Everything's been so wishy-washy for them because of the pandemic, and there's been so many changes that I've just been so stuck on that question, stuck on what's the right thing to do.
Right. Can I just have a moment to chat with Council, Your Honor? Sure. And one last question, though. Are you teaching in person or remotely?
I am in person.
All right. So I just got to ask you bluntly, right? Would this be a hardship for you to serve on this jury?
I think I'm so torn about it that I feel feel like my heart is saying that it more than likely would be. I'm so conflicted about the whole situation and whatnot that, yes.
Would the court like to inquire further?
No, the state was doing it. All right. Juror 63. I'm going to excuse you. I think it would be a hardship given the current state of your career and the students, and these times have been tough enough for us all. So I'm going to excuse you on hardship ground, and you're also excused from jury service generally. So the deputy, go with the deputy. He'll take some paperwork from you, and then you're free to go. Thank you.
Thank you.
Okay. So that was for cause. Come on up. Good morning.
Good morning.
You are juror number 64, correct?
Correct.
All right. We have plexiglass between us in front of you and also in front of the attorneys when they're questioning you.
Okay.
The question, and I'll continue to wear my mask, the upshot being you can remove your mask if you feel more comfortable doing so, but if you would feel more comfortable wearing it, just fine.
Okay.
Occasionally some people prefer just to be able to speak more clearly, but I leave it up to you pretty much.
Sure.
In either case, I would like you to move closer to the microphone so that we can hear your voice. That'd be wonderful. And before I turn it over to the attorneys, first of all, I have to swear you in to make sure all your answers are under oath. So if you could raise your right hand. Do you swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. Well, first of all, you filled out a questionnaire, and thank you for doing so. It provides us a lot of information to start with. Is everything that you put on there true?
Yes.
Okay.
At the time, at least, it was.
Well, you kind of anticipate my next question, which is, we recognize that this is months ago that you filled this out. In reflection, you might realize there was something you should have added or even changed, that it was inaccurate and you need to correct it. And even some of your opinions might have evolved and changed. Given all that, you can say something different than what's on your questionnaire, just so that you know that. It's not like you're going to get in trouble. What we want is honest and open and candid information. So if you can do that, that'd be just fine.
Sure.
Most of the time, when I ask that question, people can't come up with anything. But the attorneys are probably going to walk you through some of your specific answers.
Okay.
And they'll even refresh your memory by reading your response.
Sure.
And if it's different or changed, just let them know.
Sure.
Okay? Now, the questionnaire did tell you not to read any more articles and to avoid media on this. But we understand, given the passage of a few months, that inadvertently you may have been exposed to information. You
Sure.
see a headline, a friend talks about it, and we told you don't tell anybody you're a potential juror, so you can't exactly quiet them and leave the room. Did anything like that happen? Did you get exposed to some information inadvertently?
Yes, unfortunately. So I work for a software development company that works for a major news organization that we maintain, own, and support their applications.
Okay.
So coincidentally, right after I got the questionnaire, my team decided it was a good idea to rewrite the code base for one of those applications for better supportability and maintainability going in the future. So the last 3 months, I've been rebuilding this application, staring at this application, and these articles obviously pop up every single time, right? I'm not going into them, reading them, but I'm seeing the headlines every day. There's just no way around it.
Okay, and do you recall the substance of those headlines or the little bit of information you were exposed to?
As far as like the substance,
Either the substance of this case, or about pretrial matters, or related matters, or the attorneys, or anything at all?
not in the moment, no. I mean, unfortunately, this case is the top of the news everywhere, so it's always the very top article.
It's always there. Okay.
Yeah.
And the reason we ask this is we understand everybody's been exposed to some information. The question is, can you, as a juror, put aside all that information you've learned, put it in the back of your mind, and even some opinions you may have formed based on what you know, and
Sure.
decide this case just on the evidence you hear in this courtroom, based on the law that I give you at the end of the case?
I want to say I can. It's not to say that it's one thing to say something, then something totally different to be in the situation and feel completely different about it. So I want to say yes, but in the moment, my answer is I don't know.
Okay, I'm going to explore that just a little bit.
Sure.
Every juror I've ever met wants to do the right thing
Sure.
and is willing to do their duty and try. Unfortunately, it can't always be the case. Try, and obviously everyone wants a fair trial. And if you try and give it your best efforts, the question is, can you? And we put you in a tough spot, because what we do is we say, well, we know you've been exposed to some things, but can you put that aside when we go forward into this? And you really don't know what it is you're going to hear in this trial.
No.
And so the question is, we really need to probe a little bit to get your best answer, and there's no failure in one answer or the other. The only failure is if you tell me a lie. Do you think, looking inside yourself, that you can, not that you'll try, but that you actually can be fair and impartial here?
I believe I can.
Okay. And the attorneys might follow up on that. So,
Sure.
continue to think about it, talk about it. So,
Okay.
did you recognize any of the witnesses that were on the list we gave you?
No.
All right. And we did talk about the trial length in the questionnaire. It appears that we'll have about 4 weeks of trial starting on March 29th. If you're selected as a jury, you'd be on your own until then, and then for 4 weeks you'd be essentially working full-time on this. Could you make that work with your personal life and work life?
Yes.
All right. No hardship there as far as you know?
No.
Okay. All right. Then with that, I'm going to... Sure. always good to get advice from the lawyers. And they make a good point, which is, I didn't really ask you what this project that you're working on. Are you still working on it, or did you work at? Okay.
I still am working on it. We're at the end of it, but it's not done yet.
Okay. So some of these headlines and information that you've received may have been very recent.
As in yesterday, yes.
Okay, so even as recent as yesterday?
Yeah.
Last Friday or last Thursday even?
Every day.
Okay.
Every day, at least Monday through Friday.
Okay. And you pretty much, like you say, it's kind of the news of the day that just about every day when you're working on this and it pops up?
It's always the top.
Okay. What headlines do you recall at all? Like, what did they say?
The most recent one would be the settlement.
Okay.
Right before that, I think the most recent one would have been, it was a history of George Floyd. Yeah, those are the most recent ones I've seen.
All right. Counsel, have any further questions? All right. I think given your good faith exposure to it, I know you weren't seeking it out, but...
it's not, I mean, like, sorry, boss, I can't work on this, but, you know...
Yeah, because I'm a potential juror, and
Yeah.
I know you couldn't say that. We know it was good faith, and so, but given the saturation that you've received through your work, I think we're going to excuse you from this panel. So we appreciate your honesty in that and bringing that to our attention. You're also released from jury service generally, so unless we send you a summons in a few years, you're good to go.
Okay.
All right, you can go with the deputy. They'll take some paperwork from you.
Thank you.
All right, thank you. Sure. All right, let's do the next juror. All right, good morning.
Morning.
You are juror 66, is that correct?
Yes.
All right. First of all, I'm going to swear you in because all your answers have to be under oath, so raise your right hand. Do you swear or affirm under penalty of perjury that the testimony or that you will truthfully answer all questions about your qualifications to serve as a juror?
Yes.
Okay. I'll also advise you that we have plexiglass between us, plexiglass in front of you. The attorneys will have plexiglass in front. I will also continue to wear a mask. The upshot being, you can take off your mask if you wish, or if you either for comfort or because you think you'd be heard more clearly. It's totally your call. In either case, I would like to have you pull up to the microphone so that we can hear you nice and loud. And thank you, first of all, for filling out the questionnaire. We got a lot of good information from that. In fact, I'm going to have you write something for me in a little bit that I'm going to have you write it just so to keep your identity, because it might tend to reveal who you are, and we don't want to do that. We're being very careful about that.
Okay.
First of all, the questionnaire, was everything true on that?
Yes.
All right. Anything you wanted to change or add to that questionnaire?
I don't think so, but it was, again, a
Months
couple
ago.
Mm-hmm.
And I want you to feel comfortable in changing or adding to the questionnaire, because we realize you fill it out, a couple months go by, you reflect and you realize some things are inaccurate or incomplete. Maybe your opinions have evolved. So anything you want to change, and most of the time it's going to happen when one of the attorneys asks you a question and you say, well, that was my answer at that time, here's what you need to know now. Perfectly fine. I want you to feel comfortable being able to change or add to your questionnaire answers. Okay? Now, the advisory in the questionnaire was also to not read any more articles or go online. But we also recognize that between when you fill out the questionnaire and today, a couple months have passed, and inadvertently, you may have been exposed to some information about the case, related cases, similar cases, something about this case that you think we should probably know that you've been exposed to. Anything like that happen?
It's kind of hard to avoid it.
It is.
Completely right now. And, you know, I have gotten some information from the news, just kind of like how this jury process is run, too, because when you get that little piece of paper in the mail, you don't get a lot of information. So, you know, I have seen a little bit on the news just based on, like, how this is going. Mm-hmm.
Actually, it probably just filled you in a little bit on how we're getting the job done, it sounds like.
Yeah.
Anything about the substance of the case or any related cases that you can recall?
Nothing that stands out, no.
Other than the information you just talked about, how recently do you think you've been exposed to information about this case or related cases?
Really just this case as far as like when people are getting selected, knowing kind of how many have been picked.
Okay. Anything from like last week, or are we talking?
Yeah, last week.
Okay, and that's pretty much the procedures we're using.
Yeah.
Okay. Anything else recently that you've heard of?
Nothing stands out.
Okay. Excellent. Thank you. The whole point of this probing on how much you know about the case is for you to give us your honest opinion about yourself on whether you can put all that aside. Everybody who's come into this courtroom knows something about the case. It's some accurate, some not so accurate. But the bottom line being, you have to put all that aside as a juror, decide this case only on the evidence and the law that you receive from me at the end of the case. And the question for you is, can you do that?
Potentially, yes.
Okay. Tell me a little bit more about the potential one way and the potential the other way.
I don't know. I'm just kind of nervous.
That's okay. Almost everybody in that chair is nervous. You don't seem nervous, though, I'll tell you. You hide it well.
The mask helps.
Okay. But the only thing you have to worry about here is just telling the truth. So I hope when we get into a more conversational tone of this and that, and hope you understand we don't try and be confrontational, although we have to probe into your personal life a little bit. We apologize for that, but it is necessary. And so I'm going to jump actually right to one of those items that you did indicate on your questionnaire that you have a relative who is a state trooper. And if you were to name that person, that would probably identify you, and we don't want to do that.
Yeah.
We're trying our best to keep you anonymous. So what I'm going to do, and don't lean over because camera angles are such that we don't want you to be in a camera shot. I'm going to give you a piece of paper. I'd like you to write that relative's name down so I can share it with the attorneys, if you would. All right, counsel, let's do the sidebar. Technology is not as good as we thought, so we're just going to share the paper with the attorneys. if that's
Okay.
all right. And while they're looking at that, I'll just ask you straight out, that name was not on the witness list that you saw, correct?
No, this is my cousin.
Okay. Is there anything, or is anybody else on that witness list look familiar to you?
Yes.
Okay, and who is that?
Jason Otto
Okay.
is a friend of a friend, or I'm co-workers with his husband and friends with him.
Okay, and what is his occupation?
He is the Minneapolis Park Police.
Okay,
I don't know his exact title.
all right. If that person actually testified in the case, do you think that your relationship with them might make it hard for you to be fair, or to put aside, oh, well, I know that person, so they're going to be higher in credibility automatically just because I know them, or do you think you can treat them like any other witness?
I would probably take their views as higher, yes.
Because you have a
Friendship.
friendship with him, and so pretty much take everything he says without a grain of salt, so to speak.
Yes.
Okay. Council, why don't we do this? We're going to try this again. See
Okay.
if it works. And what I'm talking to the lawyers about is this person going to be a central witness? Does not appear so. In fact, might not even be called. Knowing that, do you think you could still remain impartial in deciding this case?
No.
Okay, tell me why.
I don't want to be a part of this trial.
Okay.
So I think that's a big part of it.
Okay. Any specific reason? I'm going to flip to the last question on the questionnaire because I think that might be the best.
From when I filled out the questionnaire till now, more life changes have happened. Recently sold my house and would be moving out of our home during the trial, which would
Okay.
be really stressful if I can't help with that. I also have a child under 1 that I don't want to be away from them for that long.
Okay. And also, if you're deliberating and it goes overnight, you'd be kept in a hotel. You understand that?
Yeah.
Does that work?
No.
Okay. Let me talk to the lawyers one more time. Do you think it would be a hardship, basically?
Sorry?
Do you think it would be a hardship for you to
Yes.
serve on the jury? Okay, you're pretty adamant about that, too. Okay. Mr. Nelson? Mr. All right. I'm going to excuse you on the basis of hardship from this case.
Thank you.
Sigh of relief for the record. That's all right. It shows you're being honest. You can go with the deputy. You're also released from jury service generally, so you don't have to report for any other cases.
Okay.
And
Thank you.
unless you get a summons in the future, a couple years from now. So, okay?
Yes, thank you.
All right. You bet. Just an observation, 8 out of the last 11 have been cause, so we're grinding to a halt. Nobody's fault, obviously. Cause is cause, so. But just an observation. We'll go with number 67. come on up and have a seat. Good morning. You are juror number 67?
Yes.
All right. Well, first thing I'm going to do is swear you in so that all your answers are under oath. If you could raise your right hand. Do you swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror?
Yes.
All right. Now, I'm going to continue to wear my mask. You have plexi between us and plexiglass in front of you, and also the attorneys have plexiglass in front of them. The upshot being, if you wish for either comfort or to be heard more clearly, feel free to remove your mask while you're being examined. Totally up to you, but whether you have it on or not, if you could pull up a little bit to the microphone doesn't work well.
How's that?
It works, but yeah, that's
Yeah.
good. It is not very flexible, so you have to move instead of the microphone. So with that, you filled out a questionnaire, and thank you for doing that because it provided a lot of good information for us. Is everything on that questionnaire true?
Yes.
And I sometimes say still true because it's been months, and so we recognize that there may be information that you realize on reflection was wrong and you need to correct, or stuff you should have added to it, or maybe even your opinions have evolved. In any case, right now, can you think of anything that you would add or subtract?
No.
Okay. The attorneys in their questioning might prompt a memory or something. Feel free to volunteer any of the information. The bottom line is I want you to feel comfortable adding or subtracting. If it's different from what was in the questionnaire, that's just fine, given the passage of time. Now, the questionnaire also advised you not to read any articles about the case to avoid the media about it. And have you been able to do that pretty much?
Yeah, for the most part.
All right. Several months have passed since the questionnaire, and so we recognize that sometimes inadvertently you get exposed to some information, either about this case or about related cases, or the attorneys, parties, whatever, something that could be relevant to sitting on this case. Have you been exposed to anything like that, like a headline, a newspaper blurb before you're able to turn the channel, anything like that?
So I've seen just like jury selection has started, article, headline.
Yeah.
I don't really
Okay.
read the news.
Okay, well, that's fine. Other than the procedures we're using, which are now not a big surprise because you've been subjected to them, anything else you can think of that you may have seen?
No.
What do you think was the most recent thing you've seen about, been exposed to?
Just that, jury selection had started.
Oh, okay, great. Now, the whole point, we go over that, and everybody's got some information about the case in the past year. The question is, can you put all that aside, what you've heard outside the courtroom, and decide the case just on the evidence you hear in the courtroom and the law that I give you?
Yes.
Okay. Any concerns about that? Being able to kind of separate and...
No.
Okay, excellent. All right. Did you recognize any witnesses on the list you were given?
No.
All right. The trial is going to be about 4 weeks long, we estimate, and it's going to start March 29th at 9 a.m. and go for about 4 weeks, where you're essentially working full time on the case. Does that work for you both as personal life and professional life?
I will make it work, yes.
And that's the key phrase. We understand that to some extent, jury duty can be a burden on everybody, but if you can make it work, that's what we need to know. So I appreciate your distinction there. It's a very important one. All right. Unless you have any questions for me, I'm going to turn over to the attorneys.
Nope.
All right. Then as to juror number 67, Mr. Nelson, you may inquire.
Morning, sir.
Good morning.
Thank you for being here. Thank you for your patience.
Yeah, thanks for having me.
It wasn't really my choice, but here we find ourselves. So what I'd like to do, sir, is I'd like to ask you a series of just kind of general questions about yourself, get to know you a little bit, and then I'm going to ask you some follow-up questions on your responses to the questionnaire, okay? When we get to the questionnaire part, I know it's a couple months ago you filled this out, and not trying to trick you. I'll read you your responses and things of that nature, okay? So let's assume that you and I were to meet in a different circumstance, a social event of some kind, a party, whatnot. What are a couple of things that I would walk away knowing about you after our first conversation?
Probably what I do and about my family.
Okay. And again, without disclosing, it's my understanding you're like a youth minister? Is that correct?
I'm an executive director
Okay.
of the organization, yeah.
Of a youth organization?
Yes.
Okay. At some point, you got this packet of information that said you were a potential juror in this case. You recall that?
Yes.
And do you recall what your initial reaction was to learning that you were a potential juror in this case?
Oh boy.
All right.
I'm also honored to be able to serve
Okay.
in this capacity.
All right. Why oh boy?
I haven't been selected for jury duty before, and being my first time and the nature of the case.
Right. And we understand you had, I'm sure, heard about the case beforehand and things of that nature, right?
Yes.
It's obviously, significant news. Did you have concerns about your personal safety in that regard?
A little bit, like, I've got a family and things like that, and just in general, but
Okay.
I know that everything is being done to maintain anonymity.
All right. And how did you feel when you came to the government center this morning and saw its current condition?
Makes sense.
Okay. And do you understand that at some point, we don't know when, but it's very possible that your name would be released publicly?
Yes.
And are you okay with that?
Yes.
Okay. In your personal or professional life, can you think of a situation where you've been called upon to resolve a conflict between two people?
Yes.
So how do you approach a situation when two people are having a dispute?
Seek to understand both sides and find common ground.
Okay. And how about, well, let me ask you, as a potential juror in this case, there's obviously a big dispute for you to resolve, which is the state of Minnesota versus Derek Chauvin, right? But within that jury room, there may be disputes that arise. How do you, let's take a hypothetical, right? One group of jurors is looking at a particular piece of evidence and saying it's extremely important. Another set of jurors is disagreeing with that and thinks it's irrelevant, that same piece of evidence. How do you approach that situation?
Again, kind of try to go back to finding out what we have common ground on, and then having each of the parties kind of express why they believe that it is important, and then trying to come to an agreement.
Okay. And if you were the juror who thought that this piece of information was super important and others disagreed with you, so you're now not trying to resolve the dispute, you're a part of the dispute. How do you deal with that?
I would want to check my own bias and try to understand if I'm, thinking wrongly about it, and be willing to be open and listen to others' input.
Okay. Are you willing to re-examine your own beliefs or your own perspectives about something?
Yes, of course.
What if you don't change your opinion after you re-examine your own bias? What if you're convinced it's still the most important piece of evidence and others disagree with you? Do you abandon your belief simply for the sake of consensus?
I don't think I would abandon it, but I would try to continue to move forward with other parts of the whole trial. If that makes sense.
In your personal or professional life, can you think of a situation where you have been called upon to determine whether someone is telling the truth about a situation?
Yes.
how do you approach that situation?
I'd ask a lot of questions and just try to get a read on the person, and I try to empathize with them as well, and see, from their perspective, what's going on.
Okay. Can you think of a situation in your life where you have been 100% convinced of something, only to later learn you were wrong?
Yes.
Okay. And tell me, what's your response to a situation like that?
I'm apologetic, kind of blown away at how convinced I can be at something and then be totally wrong. It's humbling.
Okay. And if you were a juror in this case, you understand that you you would be a judge, in a sense, a judge of the facts of what happened. But at the end of the case, the judge is going to give you the law that you have to apply the facts as you determine them to be. Can you apply the law that the judge gives you, even if you think it is wrong or should be changed?
Yeah.
Okay. No problem with that?
No.
And you believe that you can be a fair and impartial juror as a part of this process?
Yes.
So I'm going to follow up with some questions on your questionnaire.
Yeah.
And I want to start by, again, thanking you for taking the time to fill this out. We understand that everybody has some degree of knowledge. This is obviously a major case, and that everybody has some degree of knowledge about what's happened. Or what's alleged to have happened, I should say. So the first question you were asked is to just kind of write what you knew, and you wrote, the police were responding to a suspected counterfeit bill and pulled over George Floyd, who was driving under the influence. Mr. Floyd resisted, and Derek Chauvin put his knee on Mr. Floyd's neck to restrain him. Mr. Floyd died in that position in police custody. There are more details, I'm sure, but I don't recall them all exactly. That's what you wrote. Since writing that, I think the judge has asked you a few questions about what else you may have learned, and that was limited to sort of the jury selection process. Mm-hmm. Is that a yes?
Yes.
Sorry. Yes, sorry. Nothing else stands out in terms of what you recall about this event?
No.
All right. You were asked a couple of questions about your general impression of Mr. Chauvin, as well as your general impression of Mr. Floyd, and you checked both somewhat negative and neutral as applied to both individuals. Do you recall doing that?
Yes.
Okay. So it's fair to say that to some degree you have formed a negative impression of Mr. Chauvin. Would that be fair?
Yes.
And that's okay. You're perfectly entitled to your opinion. And is that simply, as I understand what you wrote, is I don't know them or fully understand the situation they were facing in the moment, but Mr. Floyd died in their custody. That's what you wrote. So explain to me why you have a somewhat negative opinion of Mr. Chauvin as well as a neutral beyond what you wrote.
Yes. So I haven't met either of them, so I don't know them. I don't know the situation that they were in. But for both parties, it just looks bad. And so, given that, I have a somewhat negative.
I mean, someone died,
right?
And that's tragic and sad, right?
Yes.
With respect to Mr. Floyd, you wrote, again, I don't know him personally, but he was under the influence and resisted police.
Right.
And so you formed a somewhat negative impression of Mr. Floyd because of what you understand to be the facts about him at that time.
Correct.
That's a fair assessment?
Yes.
I don't want to put words in your mouth, but, obviously I just want to make sure you're the right juror. You wrote that you had seen some video of Mr. Floyd's death, and I want to make sure we're talking about the same video. A video was taken by a bystander. That video was uploaded to a social media platform. That video went viral and became a news story. Is that the video that you understood this question to be about?
Yes.
Other than that video, have you seen any other videos that were released publicly?
No.
Okay.
I don't think so.
So there were some body camera videos that were released. There were some store or some security surveillance videos. You never saw those?
No.
And you checked that you had seen that bystander video 2 to 3 times. So was it, let me ask you this, did you see a long form or a more complete version, or did you see clips on the news?
Yeah, I saw clips on the news or like on social media, just, you know, scrolling as pops up kind of thing.
Okay. Did you ever watch what we would describe as the entire bystander video?
No, not in entirety.
Okay. You were asked about your conversations with family, friends, or social media commentary that you may have made, and you wrote that you had talked about it, and that Mr. Floyd, your opinion was that Mr. Floyd's death was wrong, and we should speak up and speak out against racism.
Mm-hmm.
So you used the word wrong. What did you mean by Mr. Floyd's death was wrong?
That he shouldn't have had to die. Whatever caused that death, I'm not sure of, but someone died, and that is wrong.
Okay. And how does his death attach to conversations about racism?
Because I think that was the main conversation that everyone was having, was that it was a white police officer and an African American man.
Okay. And I mean, so again, you know, it's your right to have an opinion, and your right to form those opinions based on your own experiences, your own belief system, and nobody's questioning that, right? The question becomes, however, can you take those opinions that you've formed, can you set them aside and judge this case exclusively on the evidence that is presented in court?
Yes.
And even if you may have learned certain information from those conversations or from the media, some of that information may not be in court. Can you set that information aside and judge it exclusively based on what's in court?
Yes.
All right. You were asked a question about whether you had participated in any demonstrations or marches, and you wrote, no, but we did talk to our kids about it and pray for everyone involved. Can you tell me a little bit more about that?
After everything was happening, we shared with our kids at home just kind of what was going on, and tried to explain it to them, and then prayed for everyone involved and prayed for everyone that was going out and protesting, marching, and prayed for the families and everyone involved. Yeah.
Did that include Mr. Chauvin?
Yes.
You were asked a couple of questions about the aftermath, so to speak, of Mr. Floyd's death. In terms of the protests, you indicated that a couple of businesses that you frequent or have been to were vandalized in the course of the riots. Anything about that situation? Like, have you had conversations with those store owners about their experiences?
No.
Okay. You just happened to have been to a place and it was looted or vandalized in the rioting, right?
That's correct.
Okay. You were asked whether you felt the aftermath had a negative or positive effect on the protests. And you wrote, I think the whole community has been affected in both positive and negative ways, yet I hope that we are all better people as a result of it all. Right? So let me ask you this. Do you draw a distinction between protesting and rioting?
Yes.
Okay. Can you explain for me what you see the difference in those two things to be?
I think that protesting is peacefully gathering to raise awareness about a social cause or a cause that you have, whereas rioting is just kind of going wild in the streets.
Okay. And do you associate those individuals who were peacefully protesting with the rioting?
No. I think some of them may have crossed over in some ways, but no, there was peaceful protesting, and then there was also rioting.
Okay. You were asked a series of questions about your contact with police in your personal life and whether you or someone close to you had been a victim of a crime. And I need to ask you, or just tell you, you obviously have a right to have that kept private because you answered a question that I'd like to ask you about. And so are you comfortable talking about what you wrote here in court today?
Yes.
Okay. You wrote that when you were young, your parents would fight and the police would get called to those situations at times?
Yes.
Okay. How old were you approximately when that was happening?
Probably about, I think it was about, well, it was multiple times. So
I'm sorry?
It was multiple times.
Oh, gotcha.
So I would say age 11, 12 through like 15, 16.
Okay. So your parents had a relatively tumultuous relationship?
Yes.
Right. And when you say when things got out of control, you would call the police yourself?
I did, and then my sister did as well.
Okay. Did those events turn physical? Is that what you mean by out of control, or
yes.
just okay? And when the police came or responded, you wrote that you felt that you were somewhat satisfied based on their response, and you wrote, "I don't remember the police as much as the situation." So do you think that based on what you do remember of the police involvement in those events, do you think that they handled the situation well as far as you were concerned?
I think so, yes. I was just more focused on my parents and, not the officers.
Right, understood. And were either of your parents ever arrested as a result of these?
Yes.
Okay. Were you ever called upon as a witness or to be a witness against your parents in court?
No.
Okay. Do you know if your parents had to go through the legal either one of your parents, whichever one it was, had to go through the legal system as a result of those incidents?
I don't think so. It was just kind of they were drunk and fighting and would sleep it off and then come home.
Okay, gotcha. So alcohol was involved in these disputes?
Yes.
Okay. Is there anything about those memories that would affect or impact your ability to be a fair or impartial juror, both as it applies to Mr. Chauvin, but also to the state of Minnesota?
Could you state the question again?
Sure. Sorry, it was a little confusing. I mean, we all come to this with our own personal life experiences, right? And you know yourself better than we do, and I'm asking you whether anything about your kind of upbringing or these situations with your parents that would bias you against either Mr. Chauvin or the state of Minnesota? No. Okay. You can set that aside. You recognize it's a different situation than what we're dealing with here?
Yes.
Okay. You were also asked about whether you had ever seen the police use more force than was necessary, and you wrote, "One time in Georgia, some police thought we broke into a skate park. They were not physically forceful, but verbally quite aggressive for the situation." Can you tell me more just about what happened in that situation?
Yeah, so we showed up at a skate park and the owner had hidden a key for us, and so we went in and were skating in the park in the middle of the night, and police officers arrived and thought we had broke in, and were pretty forceful in their language and how they treated the situation because of their perspective. And we were like, it's okay, it's fine, we have a key, the owner let us in. And so it was kind of just a misunderstanding. But I do understand from their perspective, like, we were in the park and it's closed. So it makes sense.
And it was, you said, the middle of the night?
Yes.
Okay. And so you understand that they may have perceived that as a crime occurring, right?
Right.
And when you say that they were aggressive in their language, were they like cursing at you and things of that nature, or were they just very forceful in their, like were they yelling at you?
Very forceful.
Okay. But ultimately you were able to resolve this misunderstanding?
Yes.
Okay. You recognize that sometimes police officers have to use verbal force?
Yeah.
Anything about that situation that would, again, either bias you against Mr. Chauvin or the state of Minnesota?
No.
Okay. You were asked if you have ever been put in a chokehold, and you checked the box yes, and you said just as a kid, probably wrestling with friends. Like someone grabbed you around the neck or something, or what happened there?
Yeah, just in wrestling, hanging out with buddies, you know.
Okay. But you've never received any formal training on how to put someone in a chokehold or being put in a chokehold in any way?
Correct.
All right. So there are a series of questions, or I should say statements on this questionnaire, and you were asked to rank your thoughts on these questions, or your agreement or disagreement about these statements. Do you remember that generally? I know you don't remember the exact statements, but do you remember that generally in this process?
Yeah, somewhat.
Okay. So I'm just going to read a couple to you and ask you to kind of explain why you may have answered these that way. Make sense?
Yep.
All right. You wrote, police in my, or the statement was, police in my community make me feel safe. And you somewhat agreed with that. Why would you somewhat agree with that versus strongly agreeing with that or disagreeing with that?
Sorry, what did I put again?
Somewhat agree. I somewhat agree.
Yeah, so I would say, like, most of the time, yes. Sometimes being a skateboarder, you know, you get yelled at and stuff like that, and so it's like, well, I don't feel safe when I'm being yelled at for cruising down the street or whatever. But
okay.
So
in your hobby as a skateboarder, you've been hassled by the cops here and there.
Yeah.
Skating where you're not supposed to skate, kind of a thing.
Yes.
All right. And do you recognize they're simply telling you to follow the law?
Yes.
All right. Anything about that would make you biased again? You understand this case involves a Minneapolis police officer, and there will be police officers who testify in this case. Do you understand that?
Yes.
Anything about your feelings or those experiences that, again, would bias you for or against either party?
No.
All right. The statement is read. The statement reads, discrimination is not as bad as the media makes it out to be. And that's an awkward phrase, but so discrimination is not as bad as the media makes it out to be. And you somewhat agreed with that. Can you explain your thinking in that?
So I think discrimination does exist. I think that the media amplifies it for good reasons or bad reasons. I think the media just amplifies it.
Okay. There is a comment or a statement here that says, police in this country treat whites and blacks equally, and you somewhat disagreed with that.
I think that, again, most of the time, I think that there is some equal treatment, but there is times when there is, where people are treated differently because of the color of their skin.
Okay. And then there was a statement that says, I think that news reports about police brutality against racial minorities is only the tip of the iceberg, and you strongly agreed with that statement. Why would you strongly agree with that statement?
Because, could you read the statement one more time?
I sure can. I think that news reports about police brutality against racial minorities is only the tip of the iceberg.
Yeah, because I think that, again, the media tries to amplify all of the situations. I think there are a lot of broken pieces to our whole system and racism and justice, and so I think it is the tip of the iceberg. There's a lot of things that we need to work on as humans together, but I think that the media tries to amplify it, which can be good or bad, depending on how they do it.
Okay. You were asked a couple of questions about your perceptions relevant to the Black Lives Matter and the Blue Lives Matter, whether they be movements, organizations, or a combination of both. And you wrote that you are very favorable that Black Lives do matter, but not favorable of the BLM organization. Can you explain that?
Yeah, so I don't know a whole lot about the BLM organization, but I do believe that Black Lives do matter.
Okay. And with respect to the Blue Lives Matter statement, you described that you were very favorable of the Blue Lives Matter, and you wrote, I am for life, both black and blue.
Yes.
Just a couple of other questions here. You were asked a series of questions about your opinions regarding the the justice system. And you were asked, do you believe that the jury system in this country is a fair system? Why or why not? And you wrote, my general assumption is yes, but I don't really know because of my limited knowledge. So can you just, again, expand on that a little bit? Are you just saying, I don't know anything about how the jury system works, and you're assuming it? I mean, explain.
Yeah, I assume that, yes, it is fair. I think that we work hard to try to make it as fair as possible, but again, I don't know all of the inner workings of it, and so, yeah.
Okay. The second question was, do you believe our criminal justice system works? Why or why not? And you wrote, it depends on how you define works, and in quotes. And you said, I think sometimes it does and sometimes it does not. There is no perfect system. So how would you define the word works in that context?
So I would say that is justice administered? And I would say, again, majority of the time, yeah. But sometimes we get it wrong.
Okay. You were asked about the presumption of innocence in criminal cases, and you wrote, I agree and I am thankful for this liberty, yet in my faith we are all guilty of wrong, and you cite a biblical reference. You understand that the so-called moral law is not applicable here. Do you understand that?
Correct.
The judge will define what the law is for you, and your job would be to determine whether or not there's a conviction or an acquittal in this case. Do you understand?
Yes.
And that would be regardless of your faith.
Right.
You were asked whether you wanted to serve as a juror in this case, and you checked yes, and you wrote, I would like to participate in justice. Can you define the word justice for me here?
That which is just and right.
Okay. Have you formed an opinion one way or another what constitutes justice in this case?
No.
Would you agree that justice could involve a not guilty verdict?
Yes.
May I have a moment, Your Honor?
All right. Juror number 67, we're going to excuse you from this panel and also from jury service generally, so you won't be needed on another case. And so you can go with the deputy, they'll take some paperwork from you, and you can go about your business. Thank you, though, for taking the time for the questionnaire and answering our questions.
Awesome. Thank you.
All right, let's take our 20-minute mid-morning break. 11:15, please. Juror 69, correct? All right. All right, sir, come on up and have a seat right in the chair. All right, you are juror 69, is that correct?
That is correct.
All right. First thing I'm going to do is swear you in so that all your answers are under oath. If you could raise your right hand. Do you swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. Just a note here, I'm going to continue to wear a mask. You have plexiglass between us, plexiglass in front of you. The attorneys will be at the lectern with plexiglass in front of them. The conclusion being, if you would like to remove your mask for more comfort or to speak more clearly if necessary, feel free to do so. Okay. But pretty much your choice. Okay? In either case, mask or not, if you could move up closer to the microphone so that we can pick up your voice nice and loud. Perfect. Well, first of all, before I turn you over to the attorneys, I have a few questions of my own. Starting with, you filled out a questionnaire, and thank you for doing that and getting back to us. It gives us a lot of information. Is everything on that true and correct?
It is.
All right. Any changes or additions to the questionnaire?
No, I don't believe
Okay. And it's very important that you understand that it's okay to do that because you filled this out months ago. In the meantime, you might have reflected on things and realized, I should have said this, or that was inaccurate, I need to correct that. Or even some of your opinions may have evolved and changed. So,
Oh, sure.
if you say anything that's different from the questionnaire, that's perfectly fine. So don't worry about that. Now, the questionnaire also advised you not to read any media, to avoid the media about this case. But we also recognize it was a couple months ago, and inadvertently you may have been exposed to some media, some headlines, maybe a news blurb before you were able to change channels, something like that. Did that happen to you? Did you get exposed to some information about the case?
Yeah, I would say scrolling through like Instagram or something, I would see headlines maybe about just like the recent news of like Minneapolis paying out to George Floyd's family.
Okay.
And then something about a third-degree charge, but I kind of skipped past that. So.
All right. Talk about the third-degree part first. You don't recall any substance other than it was mentioned? Did you?
That was pretty much it. That there was, I read like the Chauvin case and third-degree charges were brought up, and then jumped past that.
Okay. Now, as far as the thing from last week, what specific details do you recall?
Just looking through, let's see, it would have been Star Tribune saying payout $27 million, or something like that.
Okay.
To the family.
Now, you understand that was a civil case, different parties, different legal issues, different laws, and really has no bearing on this case.
Right.
But even though from a legal point of view, everything I've said is true, do you think that would make it hard for you to be impartial, or does that push you one way or the other in this case?
Oh, no, it doesn't.
Okay. Can you put aside what you heard and just decide this case on the facts and what you hear in the courtroom?
Yes.
And that's true generally of everything, because everybody, that's why the first question we asked was, what have you heard? Everybody has some knowledge about the case. Some is accurate, some is inaccurate. But whatever you've heard about the case, and I'm sure most people have formed various opinions related to those, what they've learned, you have to put all that aside. Decide this case just on the evidence, objectively, and apply the law as I give it to you. Despite being exposed to some things, do you think you can decide this case objectively, fairly, and above all, impartially?
I do.
Okay. Can you put everything else aside?
Right.
Okay. Did you decide, or did you recognize any witnesses that were on the list we gave you?
I did not.
Okay. We have estimated that the trial is going to be about a month long, starting March 29th. essentially start then and go for 4 weeks. Does that work for you personally, professionally?
I mean, it's just getting into the busy part of my job.
Okay.
You know, we have projects ramping up, but I'm sure that's something that we could figure out.
Okay. And it's more a question of can you make it work, because we know that there's a certain burden on everybody for jury duty, and we appreciate that, and we try and accommodate if it's an extreme hardship, but it sounds like you can make it work?
Yes.
All right. All right, then, unless you have any questions for me.
I do not.
All right, then I'm going to turn over the attorneys. With regard to Juror 69, Mr. Nelson.
Can we have a brief?
Sure. I'm just going to talk to the attorney. All right, Mr. Nelson.
Thank you, Judge. Good afternoon, sir.
Good afternoon.
Before I kind of go into the questions I have for all of the jurors, I just wanted to follow up a little bit in terms of your knowledge about this recent settlement that was paid out or is to be paid out by the city. If you were in the jury room, right, and people are kind of, they're discussing guilty or not guilty, would you in any way bring up that settlement as, hey, look, the city agreed that there's some liability here or whatever? How would you take that information into the jury room?
I mean, I guess, if it's not something that should be part of it, I just wouldn't even bring it up.
You wouldn't even bring it up?
If it's not part of this case, then I wouldn't, it doesn't have a spot in it.
Well, I think what we're telling you is it's not a part of this case. It's,
right.
It's a different case.
Right.
Different legal standards. Do you
Right.
understand that?
I understand.
Okay. And we just need to make sure that we're not going to have that information in some way affect the judgment in this case.
Right.
And you can do that?
I can do that.
Okay. All right. Sorry, I just wanted to explore that a little further before. We don't want to waste anyone's time.
Yep, makes sense.
So I'm going to ask you a series of questions generally, just to get to know you a little bit better. And then I'm going to ask you some specific questions about some of your answers on the questionnaire.
Sure.
Again, we understand that it's been some time since you filled this out, and I'll read you your responses. We're not trying to trick you. Okay?
Yep.
All right. So if you and I were to meet at a party or some sort of a social event, and we had our first conversation, what are a couple things I'd learn about you in that conversation?
Pretty much, I just love doing anything outdoors. Avid fisherman. I mean, you name it. Just hard worker. Want to be outside.
Okay.
That's about it.
Fair enough. You avid fisherman, you said?
Yes, sir.
Okay. Like most Minnesotans, right?
Yeah, you gotta.
All right. I'm going to ask you, because of the mask, and you may need to come a little closer to the microphone for me if you don't mind, because I also have kind of bad ears. Thanks. So at some point you received this packet of information, right?
Yep.
And you learned that you were a prospective juror in this case. And you'd obviously heard about this case before. You knew that. What was your initial response to this jury, to learning that you were a potential juror in this case in particular?
I mean, I wasn't really excited about it, just given the kind of global scale that it has reached. I wasn't really looking forward to it. I don't know.
You said you were not looking forward to it?
Right.
Okay. I think you ultimately expressed some concerns about safety. Do you remember that?
Yes, I do. Just concerns about, either way, whichever this case would go, and again, the popularity and how extreme things, had happened after the event, that it makes me a little concerned.
Okay. So let me ask you, when you got to the government center this morning and you saw the fortifications and preparations around the government center, how did that make you feel?
Very secure, actually. Yeah, it looks.
Okay.
It looks good.
And how about this morning when the judge kind of told you that your video or your face isn't going to be shown if you were a juror? We're doing what we can to protect your anonymity. How did that make you feel?
Yeah, it makes me feel better. I mean, I trust that that's what's happening. So.
Okay. And if you were to, it's entirely possible that at some point in the future your name would be released publicly if you were to serve it as a juror in this case. How does that impact you?
I mean, I'm aware that would happen. I would just hope that it would be after a period of time where things can kind of cool down a little bit, and maybe not so much press about it.
Do you have? You understand there's two potential outcomes of this trial, at least theoretically, right?
Right.
A guilty or not guilty verdict.
Right.
Do you have more concerns if the verdict were to be one versus the other?
Yeah, I suppose I would if it was not guilty.
And do you think that people, do you think that would in some way affect you and how you may choose to vote in this case?
No, I mean, I am kind of like do the right thing and kind of try to live by that code. So.
Okay. And I'm going to ask you a couple of other questions about that once we get to your questionnaire. Can you think of a situation in your personal or professional life where you've been called upon to resolve a conflict between two people?
Maybe not like called on for like a verbal debate that something's happening.
Yeah, you got two friends, they're disagreeing with each other, and they turn to you and they say, Juror 69, help us resolve this dispute.
I would say not really, no. If they are in front of me having a dispute, I would say like, let's break it up or.
Right. So you understand if you were to be a juror in this case, ultimately there's kind of global big disputes, right, in terms of is it a guilty or a not guilty verdict. There's a dispute between Mr. Chauvin and the state of Minnesota here right now.
Right.
I understand that. And you'd be called upon to potentially resolve that dispute.
Right.
But then also within the jury room itself, right, you got 12 citizens, and there may be disputes about the importance of evidence or testimony. So how would you picture yourself simply approaching the task of resolving a dispute?
I would lean on evidence that was brought up and try to stick to facts and just be like, let's look at this and tackle this piece of evidence and weigh it and see, like, how does this affect the outcome here?
Okay. So let's say, for example, that there was a particular piece of evidence, right, that you felt, this water bottle is the answer to this dispute, to solve this dispute. And other jurors thought, that's nothing, it's just a water bottle, right? How do you kind of reconcile or get to the bottom of whether that piece of evidence is important or not?
I would have to rely on any notes I took and say, like, hey, I really think there's something here. It's worth discussing at least, and we need to come together as a group to at least address that this is an issue.
Okay. And what about if after that process of doing that, you were still convinced it was important, but the others weren't? Are you the type of person that's going to agree with the majority simply because you want to build consensus? Or are you going to stand your ground and say, no, we really need to take this into consideration?
I think after, we had all talk about it, that if the group votes on it, then it's a dead issue there.
Well, I guess that's sort of the question, isn't it? Any verdict has to be unanimous.
Right.
Right? And if you really believed that
Right.
that was important, are you going to just abandon your belief about that piece of evidence simply to reach an agreement?
No.
Okay. Are you willing, however, to re-examine your beliefs about the evidence or the material that's presented in court?
I would say yes, I'd be open to re-looking at that.
Okay. Can you think of a situation, again, in your personal or professional life where you have been called upon to determine whether someone is lying about something?
Yeah, no, I don't really get caught up in that.
Probably not?
No.
Okay. So, as a juror, as the judge mentioned earlier, is one of your roles is to assess the credibility of witnesses in this case. And it's a fancy way of saying, do we believe this person, right? How would you approach the analysis of whether someone is credible or not credible, whether they're lying or not?
Geez, I don't know, that's a good question. I just try to listen to what they have to say, basically, and I don't know, just determine based off of cues of, how they're acting, or I guess first and foremost, I would just listen to everything that they have to say. And
okay. So let's take it a little bit perhaps broader. You have two witnesses, right? And think about this in the proverbial sense. There's a traffic accident, and the issue was the light green or the light red, right? There's two people standing right next to each other, watching the same thing, and one person says the light was green, the other says no, it was red, right? So how can you kind of picture yourself trying to determine? They're both convinced, right? They both see it from their perception. They're standing right next to each other. It's the same event. How do you weigh which one to assign credibility to?
I don't think that would be up to me in that scenario, and I understand the point of the question here is, to determine if I would be able to. But if I was coming into that scenario, I would first just be like, I'm a very trustworthy person, so I would say, look, I'm sure that's what you saw, and I'm sure that's what you saw, but I guess I wouldn't put myself in the spot to say you're right, you're wrong.
Okay. I mean, ultimately, as a juror, you're a judge of the facts, right? And in a case like this, you may have two people who are observing the same incident from the same general perspective, right? Mm-hmm. And they may interpret that event differently. And it is your job as a juror to decide. So do you think you could do that?
I might have lost you there. I guess I don't understand if I'm able to, based off of facts, and then say, if I was yeah, I can see that based on this evidence that yours was green, I could say, look, you thought it was red, but it was green.
Okay. So
if that's what you're asking.
That's what I want to kind of ask you is, you can look at the other evidence that may support one side or the other side.
Right.
Right? And you would be able to assess and judge the facts of this case based on all of the evidence, not just one single person.
Right.
Okay. Can you think of a situation in your life where you have been 100% convinced that I am right, only to later learn that you were in fact wrong?
I mean, mine are day to day. My wife's always right, so I lose at battle. But you know, I'll think that I'm right on something and then forget, or yeah.
Okay.
Not on like a major. Well, go ahead.
I understand. You know, I think someone referenced like a sports statistic, right? And you may think about like, I'm 100% convinced that this athlete had this stat, and then you look it up and it's like, oops, I'm wrong.
Right.
So are you the type of person that kind of learns from that, applies it in future situations, or are you the kind of person that goes, it's not that important?
No, absolutely. I'll constantly learn from those.
All right. Again, ultimately, your role or your job as a juror is to listen to the evidence, listen to both sides, listen to the entirety of the case, and at the end of the case, the judge will present you with some rules of law that you have to apply. Are you the type of person? Well, let me ask you. Rephrase that. Will you follow the law as the judge instructs you, even if you think it is wrong or should be different?
Yes.
Okay. So I'm going to ask you some questions again on your questionnaire, not trying to trick you, not trying to suggest you're not telling us the truth, right?
Sure.
We have to take you at face value. We don't know what's really in your heart or in your mind, right? So the first question that you were asked is just a general recitation of what you knew about this case based on what you had heard or seen prior to filling this out. And I have a couple of questions about what you wrote. One of the things you wrote is that you saw a video through social media, and you wrote, "The footage was pretty clear, and I recall a woman's voice pleading with officers to ease up on George, saying he can't breathe." What do you mean by the statement, "the footage was pretty clear"?
You can make out the officers, and it was just clear video in terms of resolution, I suppose.
Okay.
And just the general sense of what had been captured that day, like on the footage.
Okay. And I'm going to just skip forward a little bit. I just want to make sure we're talking about the same footage, right? You understand, or there was a bystander who took a video of Mr. Floyd's interaction with Minneapolis Police Department. That video was uploaded to a social media platform, went viral, and became news.
Right.
Is that the video that you recall seeing?
I only saw the video footage from pretty much the kneeling stance on.
Did you say the media stance?
Yeah, I guess. No, not the media, like the Facebook video that was out there.
Okay.
I didn't see the interaction before George was detained.
Okay.
Only from that point on.
Okay. So just the only video you've seen is that bystander video that went viral and became a part of the news.
That is correct.
Okay. Not seen any of the body cameras from the officers or security cameras that may have been entered the public sphere?
Right. No, I have not.
Okay. And I think you said you had seen that maybe 2 to 3 times in whole or in part?
Just in part, clips, a couple times, yeah.
You never went and looked up the original video and watched the entire video?
No, I did not.
Okay. And then one of the other things you wrote is that as time progressed, the media started to change the verbiage from, and you put in quotes, the death of George to the murder of him. Can you just explain what you mean and what impact that had on you?
Yeah, it just seemed like, and again, I pretty much just had been looking at headlines up until the point about finding out about being selected, that a lot of different media sources were saying that it was either the death or it slowly turned into headlines saying like the murder of, and that just grew more and more over time, it seemed like.
Okay. And that is, it's fair to say that you sort of adopted that perspective for yourself, right? That opinion?
I mean, I get that it's not up to media to make that decision.
Mm-hmm.
That's what we're here for. I don't know.
Well, and sir, let me just assure you that your opinion is your opinion, right?
Yeah.
And I'm not questioning your opinion. I need to know, and we all need to know, the extent to which your opinion may bias you against either party, whether it be Mr. Chauvin or the state of Minnesota. Do you understand that?
Yes.
Okay. I mean, and ultimately in your questionnaire, you were asked if you had had conversations with your friends and family about this incident, right?
Correct.
And you were asked to share what opinions you had expressed, whether it be with friends and family, and whether or whether it be on social media platforms, right? And what you wrote was George Floyd had been murdered by police officers.
Right.
So you formed the opinion, right, that George Floyd was murdered by police officers.
Right.
So, you know, kind of go back. I mean, you adopted that stance that the media had kind of changed, right?
Right.
And you were asked in the questionnaire a question of the impression that you had of Mr. Chauvin based upon what you had seen and heard. And you wrote that you had a very negative impression, right?
Right.
And you wrote that from the video footage and people pleading for George's life, the defendant didn't let up.
Right.
So ultimately you understand that as we sit here, based on the presumption of innocence, right, have you already decided this case in your mind?
You know, I think that as all those headlines are coming through and, you know, maybe subconsciously adopting them or I have adopted them, as you're saying, it probably was easy for me to just say, like, oh, have you seen what the news is saying?
Mm-hmm. Well, I mean, in the questionnaire, there's a question that asks you about the application of the presumption of innocence.
Right.
And I think you said, in this case, based on the footage that you've seen, that it would be very difficult for you to presume him innocent. Would you agree with that?
Right, yeah.
And so, again, the question being, right, you have formed a strong opinion. It is your absolute right to do so.
Mm-hmm.
Whether it's your opinion, you're based on the media, whether it's your opinion based on conversations with friends, you are entitled to that and it's okay. Can you honestly say, I can set all of my opinions, my very strong and negative opinion, I can apply the presumption of innocence and I can listen to this case based on the evidence in court? Can you say that?
Yeah, I think it's a really tough thing for me to do, but I also think digging into like who I am and saying like set that aside, listen to evidence, because it is such a huge case that we need to do what's right, that I think I can do that.
Okay. Can you foresee a situation where what's right to do is to find Mr. Chauvin not guilty?
Can you say that again?
Sure. Can you imagine a situation where the right thing to do is to find Mr. Chauvin not guilty?
Yeah, I have thought that through my head, like, you know, is this instance that I'm aware that that is a possible outcome, so knowing that we have to weigh that and realizing that I am part of that, or would be part of that, I think I'd be able to do that, yes.
I guess what we have to be certain of is not you think you could do it, but that you can do it.
Right.
Can you set aside all of your preconceived, you know, opinions or your previous opinions, and can you tell us without equivocation, I can be an unbiased, neutral, fair juror in this case?
Yes, I can.
You were asked a question about it's what we were kind of referring to as the aftermath of Mr. Floyd's death, the protests that happened after, and you were asked whether you believe our community has been negatively or positively affected by these protests, and you wrote positively affected due to the awareness of injustice. Right?
Right.
What's the injustice?
I think there is a lot of police brutality towards certain races, of course. And I think everything that's happened in the aftermath, it has really shown light and given voice to not just local but national cases that occur.
Okay. So I guess the question again, right? You formed an opinion that what happened to Mr. Floyd was in fact an injustice.
Right.
I understand that you have some previous military service, correct?
I do.
And were deployed internationally as a part of that?
Yes, sir.
And as a part of your military experience, you had training in hand-to-hand combat and chokeholds and things of that nature.
That's correct.
You have a knowledge base that some jurors may not have, right? And the question of police training may come up in this case, and what is trained. Would you recognize that the police training that you have, or excuse me, the military training that you have may be different than what police officers are trained to do?
Yes, I'm aware of that.
And would you be able to kind of abandon your prior personal experience and apply what is trained by the Minneapolis Police Department?
I think abandon, I guess I'm not understanding your question fully, but I'm able to understand what someone else's training is and apply that to the circumstances that they're in, if that's what you're asking.
I am,
okay.
And I apologize if I'm not articulate. It's been a long morning.
Right?
No worries. You were asked a series of questions that about both Black Lives Matter and Blue Lives Matter, those terms. And with respect to Black Lives Matter, you wrote that you had a somewhat favorable opinion of Black Lives Matter, and you wrote, I am not completely knowledgeable with the organization. However, it is clear they are trying to make progress towards equality by raising awareness to events. Since you filled this out, any other opinions form about Black Lives Matter?
No, I really haven't been following any other news articles or anything, and haven't really looked into, like I had said on there, I don't really know much about the organization at all, and nothing's really changed since then.
Right, okay. And you had never heard of Blue Lives Matter?
I have never heard of it.
Okay. Do you understand what that means now, sitting here today?
I make an assumption that it's, in favor of police officers and protecting them.
Okay. And you just have no opinion of that because you've never heard of it?
Correct.
Okay. So, relevant to questions regarding the presumption of innocence, what you actually wrote was, I think it would be a little difficult in this case, given the footage that came out and the events that followed, to apply the presumption of innocence.
Right.
So, have you formed an opinion sitting here right now that favors one verdict over the other?
No.
No? I mean, you've got some pretty strongly held opinions, right?
I do.
And you have a negative view of Mr. Chauvin, You believe that he was murdered by the police, right? And you're telling us that you would have a problem applying the presumption of innocence. So again, you know, the only mistake we can make is whether we're, I think as a juror, the only mistake is whether you're, you know, telling us the truth or not, right? And that's what I need to know is, can you take these aside, apply that presumption of innocence, and be fair to Mr. Chauvin?
Right, and again, like I said on there, like I think it's really difficult based off of what I've seen, what I've heard, but also knowing, like, you know, you got to sit there and do the right thing. Then, if I'm like called upon to serve, I take that to heart and need to do what's right, guilty or innocent. So, putting that aside is something that I would internally do, that I just have to follow the right path.
May I have a moment, Eric? We'll exercise it for
Juror 69, we're going to excuse you from this jury. So, in fact, you're excused from all jury service for this term, so you're not going to be called up for another case. Unless, of course, years from now you get a summons. But the deputy will collect some things on the way out, and we appreciate the time you spent here. Thank you. All right, I have that as defense number 11. Is that correct? 11?
Yes.
All right, just some information on our schedule for tomorrow. I granted this defense request to interview the 7 seated jurors, the first 7 rather, regarding whether they were exposed to the information about the $27 million settlement. And we are arranging, we're going to do this by Zoom. I'm not going to make the jurors come in for a 5-minute hearing. So I'm going to do it by Zoom. It's discretionary anyway, so I think I am within the rules to do it by Zoom. The jurors will appear that way, and so by video, and all counsel will be on Zoom. We will just not be broadcasting the video of the juror out to the general public, consistent with our practices here. We've got it scheduled for 8:45. We've heard from 6 out of 7 of the jurors that they would be available. The examination is going to be only by the court, not by the parties. And we will then discuss each as they tell us what they know and what they've heard. With regard to the other matters, I already denied the request for additional peremptory challenges by the defense. And the motion for a continuance and or a change of venue are still under advisement.
I believe I had also asked for full sequestration of the jurors during trial.
And at this point, that is denied as well. All right, anything else? Just to give you a heads up for tomorrow. We will, despite the fact we have to talk to those 7 jurors, I think since it's only the court's examination that it might be fairly quick. We're going to summon the jurors for tomorrow morning. We'll bring in another 5 again, but at 9 o'clock so that they are ready to roll by 9:30. And then we'll try and get through as many as we can tomorrow morning. So we'll be summoning 5 in at 9 o'clock and 4 at 1 o'clock, so that they are ready at 9:30 and 1:30 respectively. All right, anything else for the record before we break for lunch? And we'll come back at 1:30 because our other jurors are scheduled to arrive at 1 o'clock, and with the orientation, it'll be 1:30. So, anything else for the record from the state?
Not for the state, Your Honor.
All right, for the defense. All right, thank you. We're in recess.
I would suggest to the court that any person who has knowledge of either that settlement amount or the plea negotiations that were the beginning of the case should just be presumed to be biased and be gone. I mean, I ended up having to use a strike on that last juror because he said he would ignore the $27 million judgment. So first of all, Your Honor, I'm asking the court to start the analysis from a presumption of prejudice based on the pretrial publicity. The court in Warren, State of Minnesota versus Warren, which is at 592 Northwest 2D, references that in light of massive, unrelenting pretrial publicity, prejudice in a jury pool can be presumed. If publicity during the proceedings threatens the fairness of the trial, a new trial should be ordered, but we must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception, quoting from Shepard. And essentially, Judge, this is what the defense has been complaining about since the beginning of this case. You have elected officials, the governor, the mayor, I'm making incredibly prejudicial statements about my client, about this case. You have the city settling a civil lawsuit for a record amount of money, and the pretrial publicity is just so concerning. And I'm looking at, you know, my remaining strikes, and I'm looking at the fact that we essentially still need 3 sitting jurors plus 2 alternates, and looking forward, virtually every single one of these people is nearly identical to this last person. I've used 11 strikes on people who have had very negative things to say, but they can be fair and impartial, and no matter how you ask them, that's going to be their response here in court. It's the rare person that comes in and says, no, I can't, right? So if we start from the presumption of the prejudice, I think that, and then also take into consideration the sum total of their questionnaires, and the cause becomes the cause challenge becomes a different analysis at that point. So I'm asking for that relief, first and foremost. Second, I'm asking the court under State versus Salas, S-A-L-A-S, 306 Northwest 2D, when someone is aware of the pretrial media, I should be given, at the very least, should be given more latitude, especially about the settlement. More latitude. My latitude was very limited in that last juror and what I was allowed to ask them about their perceptions of the settlement. And in fact, I think the court should be granting me more latitude to inquire about that under these cases. It specifically says, when a juror has been informed of matters through the news media, they'll not automatically support a challenge for cause, but this does not preclude inquiry regarding such exposure, since it might produce a fixed and prejudicial opinion. The court should view such situations with careful scrutiny and permit counsel wide latitude in voir dire inquiry because of the obvious peril to the presumption of innocence in a fair trial.
Is there anything that you felt the court did restrict you from asking about the settlement?
Well, Judge, in the pretrial conference, we had the sidebar where I asked the court specifically how far I was allowed to go. And what I heard, I mean, I wasn't saying that I didn't think that the court denied me the ability to inquire about it, but what I heard the court say was, you were going to not let me go too far about it.
I think I said, I think you have a right to go beyond what I had basically said or what they had basically said. But they had heard about it. They didn't think it was going to be a problem for them.
Well, I mean, and I just think ultimately, Judge, I mean, even then in his inquiry, when I asked him about that, he said, well, I guess if I'm not allowed to, I wouldn't talk about it. But again, I don't necessarily think the question is, are they going to talk about it in the jury room? It's what has it done to their perception of the presumption of innocence and proof beyond a reasonable doubt? And so we have a juror who's aware of it. So in the immediate remedy, Judge, I would ask that I be given that strike back and that juror be stricken for cause.
All right. Mr. Slisher, do you want to respond to all of that?
Yes, Your Honor. The state asked the court to deny the relief that's been requested by the defense because there's no reason for it. Once again, it's a solution in desperate search of a problem. I think that this $27 million settlement has been frankly overblown, and I think that that has been displayed in what we've seen so far. First, with respect to the jurors' awareness, right, we've gone through to this point, 14 jurors since the news of the $27 million settlement happened. 14. Out of the 14, only 3 had heard of it. One juror, the first juror, expressed that would cause her to, it would affect her deliberations, right? The second juror was pretty neutral. He was the guy who talked about getting headlines all of the time. It didn't make even enough of an impression upon him to mention in his initial round of questioning. It was just kind of along the list of things and headlines that he scrolled through, something he happened to see. And this third one said he absolutely could set that aside. What the defense is asking for is not a presumption of prejudice. He's asking for a presumption from this court that the jurors, the prospective jurors who he's questioning, are lying to him. I mean, that's what he's essentially asking the court to find. Because these citizens are being placed under oath, they're raising their right hand, they're telling the court what information they've been exposed to and how that information may or may not affect them. And you can see different people have things affect them in different ways. Now, we know that there's pretrial publicity in this case, and there has been since the moment the news broke and the Facebook video was released. And it's not because of any conduct of the state or government officials. What I hear him saying is, oh my gosh, we have elected officials doing their job, right? They're making statements. They're talking to their constituents. In the case of the city, they settled a civil claim because they felt apparently they needed to do so. That the government, the state, I should say, this prosecution team, again, has absolutely no control over that, nor should we be meddling in some other instance I could see where you could find fault if we were trying to control the flow of information or the outcome of the civil case. They need to do their jobs. We need to do our jobs, and we all need to stay in our respective lanes. This is one of those situations where the cure is the stating, don't just do something, stand there. And that's what you exactly need to do here. We have a process of voir dire that we put people under oath, and we ask them questions, and we get their answers. And on an individual and a particularized basis, the court, in its discretion, makes the determination as to whether or not the person should be stricken for cause or not. And we're on day 6, right? In this day 6 of jury selection, of which you had 3 weeks slotted, we have plenty of time. We have, 329 prospective jurors have been identified in this case. And we're through, what's the number we're through now? We're below 100. We have plenty of time. We have plenty of people. We can take all the time questioning that we need to determine on an individual and particularized basis whether there's prejudice to the defendant or a need to strike people for cause. That just hasn't borne out so far, and I don't think that we should overreact to what's been happening. This case is in the news. It's going to continue to be in the news. There will be a story about this case every single day, no matter what. That is going to happen. And what our job here is to determine whether the particular prospective jurors in the box have been exposed to media, if they have biases that they can't set aside, right? That's what our job is. But it's not to make a prejudgment as to the rest of the panel. As to the last juror, the defendant doesn't need to strike back in that particular instance because the juror did not demonstrate any reason to strike him for cause. He stated, and it was a considered opinion, and you saw him, right? I mean, you're observing him as he's talking. I understand he was masked that whole time, but the sincerity with which and the contemplativeness with which he gave his answer that, I could set that aside because that's my job, because that's my duty, and that's what I would do. And this particular juror is the one who would know a little bit about that, having previously deployed as a member of the Minnesota National Guard and knowing that sometimes things are hard, but you're supposed to do it, so you do it anyway. He stated that under oath. There is no reason to disbelieve him, and the court should deny the defendant's relief.
Well, a couple things. I probably was not as articulate as Mr. Nelson was when I mentioned the concern about the plea bargaining, the concern about the $27 million. But I pretty much said that it's going to be a quick road to a challenge for cause. Maybe, so that's saying I'm presuming prejudice in those. But I don't think I can listen to a juror who says, I can be fair and impartial. Yeah, I was aware of that. And to be honest, our last juror, I don't think he was lying when he said that settlement thing, I don't think that would affect me at all. I think it was more maybe perhaps a lack of introspection about the other firmly held beliefs that he had. He had a very negative opinion about the defendant and a variety of other things. And I don't think he was intentionally lying. I think it's true of a fair number of jurors. They just lack the introspection to say, yeah, I don't think I can be fair and impartial. Some have not. I don't think I have to accept a juror's statement, I will be fair and impartial, when everything I see, the totality of the circumstances, is they can't be. It's almost humanly impossible given the opinions they hold. And if they are confirmed that they still hold those opinions today, and they are that strong, and considering everything, I don't believe that's true. I think it's appropriate that I accept the challenge for cause. The state might push back and say, if they say it can be fair and impartial, you have to accept that. I don't think so. I think part of my job in a challenge for cause is to make a determination if they could be fair and impartial, not just did they say the magic words. So I guess I think I'm almost between the two positions here. This has always been my thought, that I have to consider everything listening to this juror, whether there is a challenge for cause or not, based on the totality, not just the words that come out of their mouth. Those are important, obviously. And if they say, I can't be fair and impartial, that's hard to say the reverse. And say, oh no, you can be, and sit on the jury. I mean, that's playing with fire.
I agree with you, Your Honor. I mean, the Court of Appeals, the appellate authority is very clear that you are in a position to look at the record as a whole, the totality, and make that determination on an individual and particularized basis whether or not you believe a cause challenge should be granted or not. And I think that's perfectly appropriate. I think you've stated exactly what the law is and what the process should be, and continue to be, and has been.
And I think, if I could just comment on the two issues that we have currently, there are more, but the two primary ones that are particularly pernicious here is the articles shortly before trial attributing the information to law enforcement officials about plea bargaining. That is particularly problematic, and I said so, because of its impact on the presumption of innocence. The $27 million settlement is unfortunate. It is something to consider. But let's face it, it's not just a legal decision. That's a political decision. And I think people realize that, and they realize that's not anybody in this room who's doing that. And so I think it is less problematic, but less problematic than the other articles that were out earlier. So when you have a combination of the two, I'm probably going to find it hard to say that that person, even if they say I can be fair and impartial, that I would buy it and not challenge it and not grant a cause challenge. But at the same time, there are certain people, I think lawyers get really good at this, about pigeonholing, okay, I know this, I can't consider this, I can consider this. I mean, when I'm a trier of fact, I'm probably exposed to a lot on a court trial. I'm exposed to a lot of evidence that doesn't come into evidence, and I have to affirmatively disregard it and just focus on what I have in front of me. I think certain professions, and most importantly lawyers, are trained to do that. And so I have a lawyer up here saying that. I'd probably be more likely to say, yeah, because you've had practice doing it. If I got somebody who still holds these opinions, I think it's a case-by-case basis, totality of the circumstances. I don't think I have the authority to presume prejudice. I'll tell you it is prejudicial. Those articles are prejudicial to the defendant and his right to a fair trial. But the question is, how prejudicial is it to the point where a challenge for a cause is appropriate? So I don't think it's so much a presumption as I'm going to hear from them. I'm going to make a decision on the totality and go from there.
And
I'm not necessarily going to buy everything that comes out of a juror's mouth not because I'm saying they're lying. They may just be not very self-aware, and it's very clear that they are not self-aware.
I think that's perfectly appropriate. I do want to just mention, you mentioned the third degree, the plea negotiations. Of all of the jurors we've examined so far, if my notes are accurate, we've had one state that they had any sort of awareness of that out of everyone, and that person was stricken for cause. Again, that's perfectly appropriate. We have a lot of jurors to go through. We have a lot of time to go through them, and that's the process that we can use to ensure this defendant a fair trial.
All right, Mr. Nelson, anything else? Or? All right, I'm going to deny the request to reinstate a peremptory challenge, but your observations are noted, and I think they're actually consistent, but feel free to argue strenuously in certain cases, knowing that my standard is not, they said the magic words. Okay? All right, let's move forward then with the next juror. Juror 71. Juror 70, I believe, is the one who was postponed their service.
They need to be the group. I don't think this group has done.
Oh, that's right. We're back to it's the group. We need the group. All right. Thank you for reminding me. Take any seat. All right. Thank you. You be seated. And I'm going to take this off so you can hear me for this part. Well, first of all, can you all hear me? Give me a thumbs up if you can hear me. Okay. Well, good afternoon. My name is Pete Cahill, and I am one of the judges of the district court. And you have been summoned as potential jurors in the case of State of Minnesota versus Derek Chauvin, which is a criminal case related to the death of George Floyd on May 25th, 2020. A person charged with a crime has a right to a fair trial before an impartial judge and an impartial jury. In order to make sure the jurors who are selected are impartial, the law provides that the court and the attorneys for the parties may ask questions to all the prospective jurors, which must be answered under oath. And first of all, thank you for filling out and sending back the questionnaire that was mailed to you. Your contribution to the important and serious matter at hand is best served by continuing to provide us with full and complete answers to the questions that you're going to be asked today. These questions will follow up on issues from the questionnaire and possibly other topics. After the questioning is over, the attorneys will have the right to excuse some of you from service on this jury, and I may excuse others of you for what is called cause. In either case, it does not mean that you are not a fair person, and you should not take offense in being excused. Also, I ask that you not take any offense at any question that might be asked. We must pry, to some extent, in order to explore opinions you might hold and hear about experiences that you've had that might affect your ability to serve in this case. The defendant, Mr. Chauvin, has been charged with murder in the second degree and manslaughter in the second degree. Now, during the normal course of a trial, charges may be added or subtracted, but those are the charges as it stands. To these charges, the defendant has entered a plea of not guilty, which is a denial of each and every material allegation in the charges. I'm now going to have the participants introduce themselves and then ask you if you have any friendship or acquaintanceship with them, starting with the state. Mr. Slisher.
Thank you, Your Honor. Good afternoon. My name is Steve Slisher, representing the state of Minnesota.
Hi, my name is Christina Marinakis, and I'm assisting with the prosecution.
Hello, my name is Keith Ellison, and I represent the state of Minnesota.
Good afternoon, Erin Eldridge for the state of Minnesota.
And Mr. Nelson.
Good afternoon. My name is Eric Nelson. I'm assisted by Amy Voss. Together we represent Derek Chauvin, the defendant in this case.
Thank you. Is anybody on the panel familiar with any of these people? An acquaintance, friendship? All right. Seeing no hands. In addition to the attorneys in the courtroom, other attorneys might make an appearance during this trial, specifically for the Attorney General's office. And so I'd like to know if you know any of these names. Assistant Attorney General Matthew Frank, Jerry Blackwell, or anyone else who works for the Office of the Minnesota Attorney General. Any acquaintances or relationships? Okay, thank you. Seeing no hands. Does anybody know anyone in Mr. Nelson's firm, his law firm, or had any dealings with his office? Okay. Do you recognize anybody in this courtroom? And not recognize, but do you have a relationship with an acquaintance or a friendship, anything like that? Or working relationship? All right, no hands. Now, you've been given a list of potential witnesses. Please review it before you get questioned individually. You'll be asked if you know anyone on the list. Now, one of the things the attorneys may not do in jury selection is to instruct you on the law. But I do want you to be aware of some of the basic concepts that apply in all criminal cases so that you may keep them in mind as you answer the court's and the attorney's questions. So I will instruct you as follows. First, the charges against the defendant are not evidence, and they create no inference of guilt. No member of the jury should in any way permit himself or herself to be prejudiced against the defendant because a charge has been made against him or because he has been placed on trial. The defendant is presumed innocent of the charges made against him, and in order for you to find the defendant guilty, the state must prove guilt beyond a reasonable doubt. The defendant does not have to prove his innocence. The presumption of innocence remains with the defendant throughout the trial unless and until he has been proven guilty beyond a reasonable doubt according to the law and the evidence admitted at trial. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. If you serve on this jury, you and your fellow jurors will be the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. In determining believability and weight of testimony, jurors may take into consideration the witness's interest or lack of interest in the outcome of the case, relationship to the parties, the ability and opportunity to know, remember, and relate the facts, their manner, their age and experience, their frankness and sincerity or the lack thereof, the reasonableness or the unreasonableness of their testimony in light of all the other evidence in the case, and any other factors that bear on believability and weight. If on this jury, you should rely in the last analysis upon your own experience, good judgment, and common sense. There are things you should not do during jury selection. You are not investigators. You are not to go out and do any looking, and you are not to ask people about this matter. You are not to use the internet to look for information about this case or about the law. Above all, you must not talk to anyone who is involved in the case, the lawyers, the witnesses, or spectators. Do not be offended if the attorneys, parties, or witnesses do not speak to you. They know it would be improper to contact you except through the normal jury selection process, and they will confine themselves on most occasions to a brief greeting. During the selection process, your family and friends will be curious as to what you're doing, and you should tell them that you're on a panel of potential jurors for a criminal case, and that is all you should tell them. Since that is all you should tell family and friends, that is all you should tell the general public. So, during these proceedings, please refrain from using Facebook, Twitter, or other social media to announce that you are a potential juror or to comment on this trial. You may access such social media tools, but please do not publish any information about this case or your thoughts about this case, and avoid any media coverage of this case. You do not have to stay away from people and refuse to speak to them. Do whatever you wish, but do not talk about the case, and do not talk at all to anyone who is involved. And because of the nature of the charges, this case is receiving media coverage. Excuse me. Do not read about the case in the newspapers or online, and do not listen to news about it on radio or television. This trial, including jury selection, is being televised, but no video of any other juror, of you or any other juror, will be taken at any time, now or during trial, if you are selected. Also, your name will not be used in the courtroom. You will only be referred to by your random number to protect your privacy. The audio of anything you say will be broadcast unless we need to discuss something deeply personal or extremely sensitive or embarrassing, or it would tend to reveal your identity. In those cases, I would specifically order the audio to not be broadcast. In that case, you'll still have to answer questions on the record, but without audio or video broadcast. The audio would be only audible in this courtroom. Now, with the exception of juror number 71, we'll have you wait in the other courtroom until your turn is called. Please go with the deputy who will escort you back there. Keep in mind, we are doing COVID protection, so keep a social distance, keep your mask on, and use the sanitizers as much as you want. All right, thank you. Juror 71, why don't you come on up here? Good afternoon. You are juror 71, is that correct?
Correct.
All right. All right, my computer just went dark. Okay. Well, good afternoon. A couple things before I turn the questioning over to the attorneys. First is we have plexiglass between us, and also you have plexiglass between you and the attorneys. The attorneys have an extra layer of plexiglass as well. I will keep my mask on throughout so that we are maintaining COVID protection. But this is enough so that if you would prefer, for comfort's sake or to be able to speak more clearly, to remove your mask at any time. I'm pretty much leaving it up to you. In either case, mask on or mask off, I need you to probably be a little closer to the microphone so that we can pick your voice up so that everybody can hear. So with that, I'm going to swear you in because all of your answers must be under oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I will.
All right, thank you. Well, first of all, you did submit the questionnaire, and thank you for doing that. They gave us a lot of good information. Was everything true on the questionnaire?
Yes.
Any changes or additions at this time?
Not that I can think of.
Because I need you to be aware that we know the questionnaire was filled out about 2 months ago or more. And in the intervening time, you may have, on reflection, thought of things you should have added or something that was inaccurate, or maybe even your opinions have evolved since then. So essentially, I'm giving you permission to say something different than what's on the questionnaire.
I think it's accurate.
Okay. The attorneys will probably go through some specific questions, and to refresh your memory, they will usually read your answer so that you can recall and ask you maybe to expand a bit on that. They're not doing it to be disrespectful, just to kind of remind you and refresh your memory. But at this point, you're not aware of anything that needs to be changed.
No.
Okay. The questionnaire also warned you or asked you not to read any articles, avoid the media about this case, since you are a potential juror. But we understand in the months between, you may have been exposed to other information inadvertently. You see a headline, you hear something on the radio, and you can't turn it off fast enough. So the question for you is, did you become aware of any information about this case, related to this case, related cases, anything in the time between the questionnaire and today?
I mean, like you said, it's hard to avoid the headlines. It's everywhere.
Right.
You know, if you're listening to the radio, it can come on pretty quickly, or
Yep.
you know, the 10 o'clock news comes on at night, and it's usually the top story or whatever else. So, I mean, not looking for information, but
It's there.
yeah.
Yeah, and all the jurors have been pretty clear that they try their best. It's more an inadvertent exposure as opposed to seeking out information. Do you recall the substance of anything that has come up since you filled out the questionnaire? Even about the procedures here or related cases, that type of thing.
I mean, I saw, you know, the jury selection process was starting, you know, a couple weeks ago or whatever else, when, you know, we knew the dates on the letter as well when I needed to start calling in. So, I mean, I was aware of that, obviously. I've heard talk of charges possibly being put in or out of the case. You know, I think last week there was something about some sort of settlement. Again, not trying to listen, but
Right. Okay, and let's talk about, you mentioned charges being added or subtracted, just kind of the normal process of...
I'm not sure. I guess I heard something about a third-degree charge. I don't.
Okay.
I tried to not listen to the rest of it, but...
All right, that's good. Now, as far as the settlement, what are the details you remember?
I heard there was a monetary settlement made to the family
And-
of Mr. Floyd.
And did you hear the amount or anything?
20-some million or something like that. I don't know exactly.
Okay. Well, tell me, what do you think? Do you think that prevents you from being a juror in this case? Or should prevent you from being a juror?
I don't know if that's for me to decide.
Well, how did it affect your perception of the case, of being a juror?
Probably very little.
Okay. Specifically, the defendant is presumed innocent, like I just read. Do you think that would impact your decision on being able to presume someone innocent? Some kind of settlement in a civil case?
I don't think those two are really related, I guess.
Okay. Well, civil case, different parties, different laws, even different issues.
Mhm.
Would you agree with that?
Yeah, to an extent, yeah.
Okay. Do you think it'll have any impact? Kind of, if you are the balance and you are, impartial, so not tilting either way. Do you feel that may have pushed you one way or the other?
Probably not that information in particular, I guess.
Okay. Any specific information that might push you one way or the other?
Nothing since the questionnaire. Nothing.
Okay.
Nothing since I filled that out. No.
Okay, and the attorneys will probably talk to you about maybe some opinions in the questionnaire that might move you one way or the other. And so I'm going to let them talk about that. Getting back to more mundane issues, did you recognize any witnesses who are on the list?
No, I did not.
All right. And the trial is estimated to take 4 weeks once we start on March 29th. Could you make that work, personally, professionally, and otherwise?
It'd be a bit of a challenge, but yeah, I mean, I can. I do have a wedding that I'm going to out of state early in May, but...
Okay, how early?
The first Saturday, the 8th of May.
All right. We'll keep that in mind as well.
Uh-huh.
Okay. I'm going to turn over the attorneys, but first let me say a couple things. You've done really good about not talking over. It's very important we have a good record so the court reporter can take everything down, that we not talk over each other. And the lawyers and I are the worst offenders. You seem to have already gotten that habit of just waiting till the end of the question and then answering, so kudos for that. That's the way we want it. The other thing is, when you're answering questions, is clearly you're sworn to tell the truth. Keep in mind that we are looking for honest answers, not the answers you think are socially desirable or what we want to hear. Because what we want to hear is your true feelings and true thoughts. And there's no failure as a juror except if you were to not tell the truth. Okay?
Mhm.
So whatever your opinion is, we'll accept it as long as it's from the heart. Okay?
Okay.
With that, I'm going to turn it over to Mr. Nelson as to... You may. As I said, order the audio to be turned off so that it's just in this room. I think Mr. Nelson's going to ask you some other questions first, but at an appropriate time. And if we run past it and you think it's time for a more private conversation, let us know. But I think Mr. Nelson kind of knows when he's going to ask for that. Okay?
Okay.
All right.
Good afternoon, sir.
Good afternoon.
Thank you for being here. Thank you for your patience so far today. I'm going to ask you just a series of kind of general questions and then to get to know you a little bit better, and then we'll move into some of your specific responses on the questionnaire, if that's okay. And again, as the judge indicated, we understand that this was filled out quite some time ago. I'll probably read you your responses and we can go from there, okay? No one's trying to trick you. Sound good?
Okay.
All right. One thing I would ask is just because my ears are a little bad and want to make sure I can hear you, okay?
Sure.
Thanks. So let's assume you and I met in some other circumstance, a social event, a party, whatever, and we have our first conversation. What are a couple things I learn about you as I walk away from that conversation?
I'm a fun guy to be around and very driven, involved in my career, love my family, like most people, I would assume.
Yeah.
Very involved with my family. I've got a couple of young kids, so other than that, big sports fan.
I think you talked quite a bit about your kids and in the questionnaire.
Yes.
They're younger, and you had expressed some concerns about being away from them if you were to be sequestered in this trial.
Yeah, I mean, if it's going to be any sort of lengthy period of time, yeah, it's a big concern I have, yeah.
Okay. But I assume you've had a conversation about that with your spouse?
Yes.
Okay. And you can make that work should that come up?
Yeah, it's going to, be a bit of a strain on her, and, we might have to have some support from, like, her mother, but, yeah.
Okay. And again, we'll chat about some of those things when we get to your questionnaire. So when you received the questionnaire and you learned that you were a prospective juror in this case, what was your initial reaction?
Wow.
All right.
Never been called for any sort of jury duty before, so it was kind of, I won't say shocked, but surprised, like, wow, okay. I was picked.
And ultimately, when you came down, let me ask you, did you have concerns about like your personal safety, or did you have concerns about COVID-19, anything like that?
Upon opening the letter?
Yeah, upon learning that you would be a juror in this case.
I mean, some concerns about my family's safety. I mean, I think this is, it's obviously a very publicized case, and there's, going to be a lot of people with an opinion one way or another on either side of whatever verdict. Would those people want to do harm to my family? I'd sure hope not, but I mean, yeah, it's in the back of my mind somewhere.
Okay. When you came to the government center this afternoon and kind of saw the fortification that's been erected, did that help alleviate some of those concerns?
I mean, I don't know that those were ever my concerns about coming in and out of the building and things like that. It's more what I need to be worried about my kids or my wife or my family at all, after this is all said and done, and, people find out, who was on the jury, and, whoever might have a motive to do something to somebody involved in it. I guess that would be my only real concern.
Okay. And obviously you're not the first person that has expressed similar concerns. Can you set those concerns aside, and focus your attention on the evidence in this case?
Yeah, I mean, like I said, it's going to be in the back of my head somewhere, but...
Okay. When you learned this afternoon that we are doing everything we can to protect your anonymity, did that alleviate some of those concerns?
It makes me feel better. Yeah, I mean, I think it's important to, anybody that's going to be in this position to, not be in the public crosshair, so to speak.
Sure. And if at some point your name were to be released publicly, how would that make you feel?
It makes me feel a little uncomfortable.
Okay. Can you think of a circumstance in your life where you've been called upon to resolve a conflict between two people?
Yes.
And how do you approach that situation?
Generally, I want to talk to both people individually, get their version of whatever conflict or whatever had happened and try to ask questions to both sides and really understand, what the problem is, and then, depending on what that is, maybe bring the two sides together or try to help talk through with each person individually, I guess, depending on whatever situation it is.
Okay. So as what I hear you saying is listen to both sides of the story, right?
Yeah.
What about talking to other third parties who may have seen
Yeah, definitely might be necessary.
Okay. And what about looking for other information that may help resolve the conflict, other than just persons?
Again, it probably depends on what conflict we're referring to, but yeah, I mean, if there's information available to help you make a good decision or the right decision, or to alleviate a conflict between two parties or try to bring them back together, it's probably usually the ultimate goal is to bring the two sides back together. So, if it's a work situation, they can work together, or personal situation that they can be cordial to one another.
Okay. Now, ultimately, you understand that your role as a juror is to resolve a conflict, right?
Sure.
And conflict in a broader sense in terms of the state of Minnesota and Mr. Chauvin, but also if you were a juror, you're one of 12 voices, and conflicts may emerge in the deliberation. Do you understand that?
Sure.
So, I mean, I know you've never been in this circumstance before, but how would you anticipate kind of dealing with that second problem, conflict within the jury deliberation room?
I think it's similar. You need to understand what the conflict is. Why do people feel the way they do?
Okay. Can you think of a circumstance in your life where you've been asked to decide if someone is telling the truth or not? I know it's a kind of a.
I mean, I guess I don't know if that really ends up being the determinant. Like, if I'm thinking of a work situation, that's probably not going to determine anything one way or another if that person is being 100% truthful. But yeah, I mean, I think that's part of any fact-finding mission, or if you're going to hear two sides of a story. Well, I mean, there's always an opportunity that somebody might be being less than truthful, and kind of having that, just drawing on other experiences and knowledge of the situation and things like that to form your opinion if you think something is not true.
Okay. Can you think of a situation in your life where you've been 100% certain you're right and you later learn that you're wrong?
Yeah.
Okay. How do you deal with that?
Generally just gonna own that, hey, I was wrong.
Okay.
Hopefully I didn't say anything too harsh that I need to say I'm sorry for, but yeah, I mean, I can't think of any adult that hasn't thought that they were right about something and found out that they were wrong. So,
are you the type of person who's willing to re-examine his opinion?
Sure. I mean, if facts are presented, I'm listening. Yeah.
Okay. Now, ultimately, your role as a juror is to be what's called a judge of the facts, what happened in this particular case. And at the end of the case, the judge is going to read you the law that applies to this case. And you have to kind of apply the facts to the law. Okay? Would you be able to follow the law even if you thought it was wrong or should be changed?
Yeah. I mean, the law's the law, right?
Right.
We all have to follow it.
Okay. Now, I want to ask you a few questions kind of about your questionnaire. Again, I'll refresh your recollection based on some of your answers. Before I do that, I mean, do you think that you're the type of person who can look at the evidence that's presented in court and make a decision based on the evidence in court?
I believe so.
Okay. Do you think you can, or just that you would try, or?
Yeah, I mean, if I'm put in a seat, I would do my best to follow what I'm being asked to do.
Okay, fair enough. And before I go in, You said that you had seen some media since you filled out the questionnaire, and I understand it's inadvertent and people may have mentioned things in passing, or you flip on the car radio or whatever it may be, right? And one of the things was the settlement, right? You heard about that?
I did, yeah.
And you would say it has no bearing or impact on you in terms of your analysis of this case?
I would have fully expected that to be a part of this regardless of anything.
Why would you have fully expected that?
Just things that I've come to see over the course of my life. If if one entity or one company or one department, whatever you want to call it, is I guess viewed as being responsible for something happening to either someone else or another company or whatever that might be, that there's generally some sort of monetary settlement to make people feel whole.
Okay. And the fact that the city made this determination, again, I mean, would it have any bearing? Would it cause you to, if you're in that deliberation room, right, and there's a dispute, let's say over guilty or not guilty, would you say, hey guys, the city already paid this huge settlement. We need to take that into consideration?
I don't think so.
Okay. Now, in the questionnaire, obviously, you had heard about this case before filling out the questionnaire.
Uh-huh.
That's
yes.
Yes. Okay. And it's fair to say you had formed some opinions about this case before filling out the questionnaire.
Yes.
And those opinions remain your opinions today?
Yes.
Okay. Now, I want to, before we go in, I want to make sure and clarify something here too, is there's a lot of questions about a video and how many times you've seen a video, and you referenced the video.
Yes.
I want to make sure we're talking about the right video or the same video, I guess I should say. You understand there was a bystander who took a video. That video got uploaded to social media. That video went viral. The media picked up on it, and away we went, right?
Yes.
Is that the video that you are referencing?
I believe that we're talking about the same video, yes.
Have you seen any other videos about this incident, like body cameras, security cameras, anything of that nature?
No.
And I think you said you had seen that video 4 to 5 times.
That sounds right, yeah.
And when you say you had seen the video 4 to 5 times, do you mean that you had downloaded the whole video, or are you talking about clips on various other media?
No, it would be more clips. I believe it was Facebook. I watched at least a few minutes of it.
Okay.
Continuously running. I probably watched that, 4 to 5 minutes of it.
Okay. So you watched a longer form video through social media, but then you had seen various clips.
There's been clips on the news and on TV and things like that. Yeah.
Okay. Now, the first question that the questionnaire asks you is to just sort of write down the details that you were aware of this case, where you learned it, things of that nature.
Yes.
And you wrote, I watched numerous news reports and footage of the video showing the officer kneeling on his neck while he was unconscious. You remember people asking, or people who were watching were asking him to stop. And then you finally wrote, the officer refusing to take his knee off the back of his neck after he was laying there unconscious are what I remember the most and are seared into my memory.
Yes.
Explain what you mean seared into my memory.
It's probably just a still shot of the officer with his hands on his hips or hands in his pocket with his knee on the gentleman's neck back area, and he appeared to be just motionless, sitting there. It's hard to get that the look on his face, I guess, while that was going on is kind of probably that still shot that's burnt into my memory.
Okay.
As far as what I know about this.
Sure. And when you say, seared in my memory,
yeah.
Do you think that has a negative or a positive connotation?
I think when you read it, it's probably a negative connotation.
I'm sorry?
I said if I was sitting in your chair, I would probably take that as a negative connotation, absolutely.
Okay. I'm asking you about your opinion. Right?
I think that word does have some feeling behind it, yes.
Okay. you were asked about your perceptions of both Mr. Floyd as well as Mr. Chauvin. Do you remember those questions generally?
I remember there being questions about it. My exact answers,
okay,
not certain.
So you were asked, from what you've seen, read, or heard, do you have a general impression of the defendant? And you were given some choices, and you checked the box very negative. And then what you wrote about why you felt that way, you wrote, there were protests in the city of Minneapolis causing enormous amount of damage after those events, leading to civil unrest around the country. I feel Officer Chauvin in particular took this man's life. The video shows what it shows. Right? Do you still agree with that statement?
I mean, yes, if you're asking.
Yeah.
That's.
I want to just tell you, sir, you are entitled to your opinion, right? And that's what we're asking you, is be honest about your opinion, right? And if you can be honest about your opinion, that will help us determine whether you can be a fair and impartial juror in this case. Do you understand that?
Yes.
So I'm not questioning your right to have an opinion, and even if that opinion is negative, but we just need you to be honest because we don't know what's in your heart or in your head.
Sure.
Fair enough?
Yes, that's fair.
Okay. So it's fair to say that you had a very strong and negative reaction to what you saw in that video, right?
Yes.
Okay. And you specifically say that my client, Officer Chauvin, took this man's life. Like you formed an opinion as to Mr. Floyd's cause of death, in other words.
That's fair to say that I made an assumption based on the video that I watched, yes.
Right. And again, the video, like what you write, the video shows what it shows.
Mm-hmm. Correct.
Now, you were asked a question about your impression of Mr. Floyd, and you said that it was somewhat negative. And you wrote, there are stories everywhere about his colorful past and his status when the event occurred. I would not consider Mr. Floyd an admirable person based on his life choices. Do you stand by that statement as well?
Yes, I do.
Were there things that you specifically recall hearing about Mr. Floyd? About his?
I guess I've heard about drug use, trying to pass this fake bill that kind of started all the conflict. I don't know if I heard this hearsay. I don't believe I actually read anything that said this, but I heard that he had some sort of domestic altercation where he abused a female, which I guess doesn't sit well with me.
Okay. So again, you understand that you would be hearing evidence in the courtroom, right?
Yes.
And if some of that evidence didn't come in, can you set aside what you'd heard before and judge the case based on what you've heard?
I can do my absolute best.
Now, there's a question that asks, have you ever talked about George Floyd's death with your family, friends, or coworkers, discussed it online, for example, social media? You checked the box yes. And you wrote, my only real feeling is that I think it is unacceptable for one man to choke out another man and continue to do so once he is laying motionless and unconscious on the ground.
Yes, I wrote that.
And again, not questioning your perception, your belief, your perception. Again, you're entitled to it. Right? The question is, you formed very, very strong opinions, right, about Mr. Chauvin, about Mr. Floyd, about what happened, right? And so if you've made a determination in your mind already about what happened, do you think you can just set that all aside and be a fair and impartial juror in this case?
I mean, if I'm put in the spot, I would try my absolute best to do so. Yeah, I mean, you're calling it out on the front side that, I do have a preformed opinion, yeah.
Right. And we just need you, again, right or wrong, just be honest, right?
Yep.
Okay. Because throughout your questionnaire, it's fair to say you kind of made several references to not being able to kind of unsee that video.
Yes,
and
that's true.
Under our principles of law, as the judge just explained them to you, and in this questionnaire, Mr. Chauvin is presumed innocent. Do you understand that?
Yes.
And it's fair to say that you formed an opinion about whether he's guilty or not guilty at this point, right?
Yeah.
And that's based on what you've seen and heard and read and all of that. And so I think in the questionnaire, when you're ultimately asked, could you presume Mr. Chauvin innocent, you wrote, no. But human nature can lead you to presume one thing or another based on the information you have. Right?
Correct. Yeah, I wrote that.
So, can you apply the presumption of innocence based on your prior opinions?
Again, I can try my absolute best. You know, what I wrote in there, that it's going to be hard to unsee that video. I mean, I witnessed it. I watched it. I did form an opinion about what I watched, and I mean, I've been very forthcoming about that from the start. I think, again, if you guys think I'm a good fit to be a juror, then would I do my absolute best to be fair? Yeah, I would.
So the question was presented in the questionnaire. No matter what you have heard or seen about this case, and no matter what opinions you might have formed, can you put all of that aside and decide this case only on the evidence you receive in court, follow the law, and decide the case in a fair and impartial manner? And you wrote yes, but there is no unseeing the video footage of the incident. I am not sure how watching it in a courtroom setting versus in my home would change my feelings about what I am watching with my own eyes.
Yes.
Again, sir, you are entitled to your opinion.
Yes.
And you're not the first person to have a strong opinion in this case, right? And I know you say you can try to be a fair and impartial juror, but we can't have it be I can try, because everybody comes in and says they can try. The question is, can you? Yes or no?
Yes. I mean, if I'm selected, I would try to come in with as much of a clean slate as humanly possible and listen from the start.
Pardon?
I just want to clarify some of your answers. Mr. Nelson just read the answer about yes, you can decide the case in a fair and impartial manner. Yes, but there's no unseeing the video footage. Couple things, my observations from where I'm at. I think the answer is not really. But I want to make
maybe true. Yeah.
I want to make one thing real clear. That's not a cut. People have come into this case with varying levels of knowledge about the case. One juror came in and thought Mr. Floyd had been shot. So I think a function of it, it's not intelligence or anything like that, whether you can be fair and impartial, it's not a lack of effort. It's more, sometimes it's just your exposure to the case, talking to friends, forming opinions, the strength of those opinions. And as you say, for some people, they can say, yeah, I can put it aside. Other people say, it's seared in my memory, and I don't see how it would really make a difference. But I don't want to put words in your mouth. And I don't want you to think that if the answer is not really, that's an insult by any means. It's just, it's a fact or it's not. Which do you think is the more likely answer? Is it yes or not really to being fair and impartial? And again,
I mean, with 100% honesty, yeah, I mean, I would have to overcome that opinion coming into the situation.
Sure. And can you? Or more importantly, will you?
I mean, again, I try as hard as I possibly could. I mean, when I hear his name or I hear anything to do with this case, it just seems to be one picture that pops into my head. And whether that's right or wrong, I'm just, that's my honest.
Okay. You have any further questions?
No, Your Honor.
State, have any questions?
Yes.
Mr. Slisher.
Can we make As to this issue, Your Honor?
As to this issue? Yes, as to this issue. Sure, we want to sidebar. We'll get right back to you. Hold on. I'm going to actually have you step out with the deputy back into the other courtroom just for a second so we can talk without having to try and have this thing whining in our ears. All right, we are outside the hearing of the jury. Mr. Nelson, did you want to talk? Who asked for the sidebar? Mr. Slisher.
Your Honor, and I just wanted to point out, given the nature of the challenge and how carefully we're looking at these individual jurors, I think Mr. Nelson. I can't be fair and impartial. That really isn't the question at all. There are two parts to this, right? There's what happened, and then there's what happened means. And on that, this juror was unequivocal when he said, the law is the law, I'm going to follow the law. And so in this instance, the juror stated that he saw, really out of context, a segment of a video which was disturbing. And I think that, most people would find it such, right? It's a disturbing thing to see. But the question isn't whether it's disturbing, and the question isn't whether you're going to be able to unsee it. The question is whether, if the judge instructs you, based on his instructions, you find that what you saw, that what you thought was disturbing, was actually justified under the situation because it was an authorized use of force, would you follow the law? Right? I mean, of course, if someone saw a video of a shooting, they would probably find that pretty disturbing and pretty outrageous. Of course they would. But of course, as the judge as you know, officers can, in the proper circumstances, shoot someone, kill someone, strike someone, restrain someone. They can. So the question isn't whether, when you see some conduct, whether you can forget it. The question is whether, under these circumstances, if the judge instructed you that the elements of the offense are thus, and you found that what you saw doesn't add up to a crime, would you be able to do that? And he clearly said that he would. He's not going to be able to unsee what he saw. Nobody can.
He said he would try. And we're back into the I'll try. And if you think I'm the best, that delegation to us. If you think I'm good enough, I'll try. And it's just, that's not good enough. I'm sorry.
He was pretty affirmative, I think, before we got to the third or fourth time he's asked the same question. I mean, I think that he was. And I guess what I'm saying is that the laying out of the conduct that everybody finds outrageous, and looking at that, saying, well, gosh, do you think he's guilty based on that? Without the rest of it, if you were given instructions as to what constitutes an offense, and you found that this conduct doesn't constitute an offense, would you be able to vote not guilty? That's really the question. The biased juror would be one who would say, I don't care what the law says. Based on what I saw, there's no way I could acquit the defendant.
So they have to be expressly adopting that position.
No, I mean, Your Honor, you in context.
Well,
right?
let me just ask you straight out. Do you think, if you were the finder of fact, that you would find that he, in fact, will be fair and impartial?
At this point, Your Honor, as a finder of fact, I would want to develop the record more, and that's why I would like to ask him a few questions. I don't think that I could make the finding either way at this point with what the record is, but I do think it's important that we look at both parts of it, right? Here's what you saw. Now let's talk about whether or not you could look at what you saw and still be fair and apply the law. I think that's the ultimate question, and I would like to do that.
I'll give you the opportunity.
I appreciate that.
All
Thank
right.
you, Your Honor.
Judge, I would just note the second half of his response to that, which was, I am not sure how watching it in a courtroom setting versus in my home would change my feelings about this.
All right, let's bring him back. Yeah, that'd be fine.
And it's only as to this.
Right. Okay. Yeah, we have you walk a prescribed route so that you don't get on the camera. All right, Mr. Slisher's going to ask you a few questions.
Thank you, Your Honor. Sir, Steve Slisher, represent the state. We met briefly just earlier, and I have a few follow-up questions I need to ask you just about some of the answers that you gave in response to counsel's questioning and the court's questioning about your ability to set aside prior opinions that you may have formed and judge the case fairly. All right? And so what I need to ask you, at one point you indicated that you believe that you could follow the law because the law is the law. Is that right?
Yes.
And you have no hesitation about that?
Correct.
Now, I want to pose to you a question in your ability to do that. Let's say that the court instructed you that the defendant is charged with particular offenses, particular crimes. And those crimes have elements. And the government has the burden of proving each of those elements beyond a reasonable doubt. Would you be able to hold the government to its burden of proving each element of a crime beyond a reasonable doubt?
Yes.
Now, what if, based upon your review of the court's instructions, you determined that the thing you saw, the video, right, that conduct does not constitute a crime as instructed. In other words, the government failed to meet its burden of proof. Even if assuming what you saw was introduced as evidence, that in and of itself, that is not a crime, would you be able to return a verdict of not guilty, or do you find the conduct such that you would just be unable to follow the judge's instructions?
Again, if I'm put in this situation, I'm going to do everything that I can be to be fair and listen to everything that's presented in front of me, and try to put aside any personal opinions that I have formed to this point.
And so on that question, and this is really important because the state has an interest here, and the state also has an interest in making sure the defendant has a fair trial. Okay? And so when you say you try your best, say if you were flying a plane, if you were a pilot, and I was about to hop on the plane, and I said, "Is this plane going to land in Phoenix safely?" And you said, "Well, I'll try my best." You could see that I might want to go back to the Sky Lounge and wait for somebody else, right?
Sure.
So, I mean, I need to ask you, more than try, would you be able to, if after reviewing the judge's instructions, it became apparent to you and you believed that what you saw does not add up to a crime, would you be able to find the defendant not guilty?
Yes, I mean, if I'm put in this situation where you're asking me to be fair and judge and listen to everything in front of me, I would listen to all the facts and do as I'm instructed and arrive at whatever verdict the facts bring us to.
And if that verdict was not guilty, would you enter it?
Yes.
I have no further questions.
So I think you're kind of seeing that we ask you the same questions in multiple ways to get to kind of an end result.
Yeah, that makes sense.
Right? And again, and it was pointed out to me that I may have asked you or read you a question wrong, and so I just want to clarify the record here in this regard, not trying to belabor the point. The question reads, under our system of justice, defendants are presumed innocent of the criminal charges against them. Would you have any difficulty following this principle of law? And that's what you answered no to. And you wrote, but human nature can lead you to presume one thing or another based on the information you have. Right?
Correct.
And so I guess, and then I'll move on from here, is there were several spots in this questionnaire that were asking you about, can you be fair and impartial? Can you apply the presumption of innocence? Is there any information that would make you, that we should know about you to make sure you're fair and impartial? And at each and every one of those opportunities in the questionnaire, you answered the question, but you followed it up with, but I can't unsee what I have seen, and I'm not sure how anything else would change my opinion.
Yes, I think that's fair.
Right? There was a question that said, is there any other reason you could not be a fair and impartial juror in this case? If yes, please explain. And you wrote, no, but I have watched the video and I have an opinion about what I watched and witnessed with my own eyes.
Yes.
And so it is, you're telling us now that you can, despite having every opportunity, and being asked this question 100 different ways to Sunday, right? You can just now set that aside.
It's going to take effort on my part. I don't make two ways about that. However, if I'm called to be in this position, I'm going to do everything in my ability to, uphold my civic duty and, be as fair and listen to everything that I can. Now, Having said that, we do have an opinion that I have formed that I need to overcome and try to set aside before I sit down in this setting. Yeah, I'm wrestling in my head currently. I can't paint another picture. Do I think that if I walk out of here and you say, we want you to be the juror, yeah, I will do everything I can to listen to what's presented to me once this starts.
Yeah, I mean, and ultimately that's what the presumption of innocence is, right? It's starting from a point that we don't have to overcome any of that. Do you understand that?
Yes.
And that's what I'm concerned about here, is your ability to overcome that. And I'm not questioning your honesty. I really appreciate your honesty, right? If it's the system is set up that the defendant is presumed innocent, that's the starting point. It's not the starting point of I now have to overcome your preconceived notions.
Sure.
Right? Can you apply the presumption of innocence?
Yes, I could.
Now, you were asked some other questions about kind of your availability and your family situation, and you had some different responses than you've kind of said today. Would you recognize that?
Yeah.
I mean, this morning or this afternoon at the beginning of this, the judge asked you some questions about your availability and would you want to be a juror on this case because of your work situation, right? And you said you'd make it work, right?
I could make it work. I don't believe he asked me if I wanted to be a juror on the case.
Okay. So there was a question in the questionnaire about the length of the trial starting on March 29th, and going about 4 weeks. And you wrote, I have a very demanding job and it would cause stress on my employer. Plus, I am a very involved father of 2 toddlers. My family and wife depend on me being able to watch our children. My wife not being able to work her part-time job would cause financial stress as well.
Potentially. I mean, we could overcome that, but it is going to be, something I'm going to have to deal with on the side of this. Yes.
And then they asked the question about being sequestered, the possibility of being sequestered, and you wrote, I would not like to be separated from my wife and 2 small children.
I would prefer not to.
Now, there is the last 3 questions on the questionnaire where the court asks, or the questionnaire asks, is there anything else the judge and attorney should know about you in relation to serving on this jury? And you wrote, no, I'd prefer not to be a juror on this case. It then specifically asks you, do you want to serve as a juror on this case? You check the box, no. And then, why do you feel that way about serving as a juror? You wrote, I feel like there will be a ton of media attention around this case. I am aware that it will be televised and most likely be a very historic and documented case. I feel there will be individuals that, regardless to the outcome of this case or verdict, that are going to have a problem with the verdict. I have a family to care for, and I do not want to need to fear for the safety of my wife and 2 children or myself simply for being involved in such a charged case. Right? Yes. So I need to be confident, right? I mean, because your answers in your questionnaire are much different than your answers today in terms of, can you be fair and impartial? Are you concerned about being away from your family and the financial stress? And I just want to make sure that all of these things, that you feel you can be fair and impartial.
Yeah, I mean, I think we've kind of walked through the whole scenario leading up to this. I realize you're asking me the question, the same question in another way. If I'm put in this situation where I would be a juror, would I be able to make it work with my home situation, my job, everything like that? Yeah, I could make it work. Would it be, I don't know if inconvenience is the right word, but would it you know, put me in a bit of a predicament as far as, you know, juggling a few of those things and, you know, potentially still having some other responsibilities to take care of outside of what's going on here. I mean, yeah, I'd be lying if I told you another story.
Okay.
We're going to take our action in recess. We're going to transfer back to that courtroom, and then we'll convene in 20 minutes. I'll expect a motion at that time. You have a motion?
I do. If I may have just a moment, Your Honor.
I don't need argument, I just need a motion.
Motion to strike the cause.
I'm going to grant that motion. I think both sides have had plenty of opportunity to rake this juror over the coals. I am incorporating findings from the questionnaire as well. Everyone in this courtroom is a very talented lawyer and can probably lead a juror down a path one way or the other, and that's both sides, to their desired result. My job is to figure out whether or not the person can truly be fair and impartial. I think actually this is, in fact, I'm wondering if Mr. Nelson, I'm not going to ask you to respond, if you made the earlier record and motion seeing that this individual is coming up. Because I think it is the classic case of someone who, in all sincerity, is saying he would try and be fair and impartial. But every entry in his questionnaire that's related to the presumption of innocence and being fair and impartial is a qualified answer. Specifically, the question which over defense objected, I bolded in the questionnaire, no matter what you have heard or seen about this case and no matter what opinions you might have formed, can you put all that aside and decide this case only on the evidence you receive in court, follow the law, and decide the case in a fair and impartial manner? Yes, but there is no one seeing the video footage of the incident. I am not sure how watching it in a courtroom setting versus in my home would change my feelings about what I am watching with my own eyes. Further on, and the state, I accept your argument that there are two issues here. One is what happened, and then what is the interpretation of it. The problem is when we get to that second issue, there is further equivocation. Specifically, it was a discussion of intent. I've lost my place on it. In response to question 6, had talked to family and friends. His response was, my only real feeling is I think it's unacceptable for one man to choke out another man and continue to do so once he is laying motionless, unconscious on the ground. So he actually did give an opinion that went beyond just what he saw, but what his opinion and evaluation of what that was. But my biggest concern here is that all the answers on the presumption of innocence and fair and impartial, they're all qualified, and this, I think, is a classic case that Mr. Nelson's talking about. He gives what is ultimately the socially desirable answer, but it's always qualified by, I'll try. Finally, if you can put the words in his mouth as, or I shouldn't say that, but if you can lead him to the point of saying the magic words, it's not enough in my view. I make a finding that he could not be fair and impartial, and thus I'm granting the challenge for cause. Let's go to juror number 73.
Your Honor,
Mr. Slisher, you wish to make a record?
just very briefly, Your Honor.
Yes.
Well, obviously, I disagree with the ultimate decision.
Sure.
This is clearly within your discretion, and I understand how you got there. I, just on behalf of the state, deeply appreciate you allowing me to further question the juror and be careful here because it is so important. And
And I have no problem with the state seeking to rehabilitate. So don't feel cautious in asking for that. And I'll be real honest. I think I reached this point when I turned to him and said, can I translate as yes, but to not really? And he almost kind of agreed with it. But I think that was the turning point for me. But the state always has a right to rehabilitate. Do not feel shy about asking for it.
I appreciate that.
All right. Juror number 73, please.
Do we need to excuse him?
They will. Mr. Schaefer will take care of it. Good afternoon, sir. If you could come on up. Have a seat.
Thank you.
First thing I'm going to do is swear you in because all your answers have to be under oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. A couple things. We have plexiglass in front of you, plexiglass between us. The lawyers have an extra layer of plexiglass between them. My point being that with all those precautions, you can actually take off your mask if it would be more comfortable.
Perfect.
Okay, there we go. A couple of things I want to ask you before I turn it over to the attorneys. First of all, you filled out a questionnaire. Thank you for doing that. Is there anything, or first of all, is everything true in that questionnaire?
Yes.
All right. Now, is there anything you wanted to add or subtract from that questionnaire?
I don't think so. It's been
Okay.
a while.
Yeah, and it's been a few months, and we realize that in the months that have intervened, sometimes maybe in reflection you think, oh, I should have added this, or
Right.
or maybe even an opinion has evolved. So
Yeah.
if there is anything like that, it usually comes up when the lawyers are asking you specific questions, and they will usually read your answers because to refresh your memory, not to be disrespectful or question the legitimacy of anything you said, but just to refresh your memory. But right now, there's nothing particular you can think of to add or subtract?
Nope.
Okay. The questionnaire did advise you not to read any articles, to avoid media, but in the months that have followed filling out the questionnaire until today, which is a fairly long time, it's normal sometimes that people are inadvertently exposed
Yeah.
to more information about the case, a headline, a blurb on the TV news, maybe a friend says, hey, did you hear about what's going on?
Right.
And we told you, don't tell anybody you're a potential juror, so you can't really stop people.
Correct.
Did you learn any new information between the questionnaire and today about the case, or cases that are related to this one, or the lawyers, parties, anything at all?
No, not that I can think of.
All right. Did you hear anything, for example, about any pending civil litigation? That might be-
Yeah, I heard about the judgment for $27 million.
The settlement that it
Yeah.
did? Okay. Well, it's not part of this case. It's
Right.
involves different parties, different law. But the fact that it was the Floyd family in the city of Minneapolis, how do you think that's going to affect or tilt you, if at all, one way or the other in this case?
I don't think it'll affect me at all. I was thinking about that after it came up. I thought it was kind of odd that it was the timing of it all, I guess.
Okay. In what way was it? Did you think it was odd?
I don't know. I thought in the past that it always had been maybe after.
Mm-hmm. So it was odd before a criminal trial?
Correct.
Do you take anything of it? Do you infer things from hearing about that?
No, I don't. It doesn't affect me at all.
Okay. Any other items that come up in your mind? Maybe some pretrial matters in this case, or anything like that?
Nope.
Okay. The whole point here is whatever you've heard outside the courtroom, you get, and whatever opinions you may have formed, and just about everybody in this case knows something about what went on. Some accurate, some not so accurate. You have to put aside that knowledge and any opinions you may have formed, and just decide this case on the evidence in the courtroom and the laws I give it to you. Do you think you could do that?
Yes, sir.
All right. Did you recognize anybody who is on the witness list?
I did not.
All right. Now, like the trial, there were some concerns in your questionnaire, I think, about the length being 4 weeks long.
Yes.
Tell me about that.
Well, I'm self-employed, so it'd be a financial strain on my family for me to take that much time off.
Okay.
I
Having said that, everyone bears a certain burden doing jury
Yep,
duty,
I understand. We'll figure it out.
but at the same time, we have to be sensitive to people's individual situations.
Mm-hmm.
Do you think that it would be such that, well, for one thing, would you try and be working after hours, after court time, or anything like that?
Yes, definitely.
Okay. Do you think it would be the point where you would be worn out and falling asleep during the trial?
No, I have a business partner and an assistant that can help out.
Okay. Do you think it's a large enough hardship that you would want to be off, not want to be, but should be off the jury?
Yeah, I've been thinking about that, and that's a tough call. I would think it would be financially difficult.
Okay.
If it was 4, 6, 8 weeks, whatever it is.
Well, we're hoping it's 4. But
All right.
that's a pretty good estimate, but we don't know how deliberations are though, so. Well, I think maybe we'll let you think about that and get back to it. I might let the lawyers explore that a little more.
Got it.
Anything else? Any other questions you have or things you think that I should bring up?
No.
Okay. A couple of things that before I turn it over to Mr. Nelson is you've done a really good job of not talking over me, but lawyers and judges and jurors sometimes talk over each other in this process. We are actually the worst offenders.
Mm-hmm.
And you seem to have pretty much been good at waiting till the question is finished and then answer it. That's necessary so that we have a good record being made. So if you could continue to do that, that would be great. And if you could pull up to the microphone so we can hear you really well. The microphone doesn't move very well, so I apologize for that.
All right.
So with that, Mr. Nelson, you may inquire as to Juror 73.
Good afternoon, sir.
Hello.
Thank you for your patience this afternoon. What I'd like to do is kind of ask you some general questions, get to know you a little bit, and then we'll circle back and follow up with some questions on your questionnaire. All right?
Sounds good.
So if you and I were to meet under much different circumstances, some sort of a social event or party, what are a couple things I'd learn about you during our initial conversation?
Well, right off the bat, I don't know, that I've been married for 23 years and have 3 kids.
Okay. Your kids in their teenage years?
No, I have all adult children.
All adult children. Boys or girls?
A boy and 2 girls.
Okay. And I know it's in here, but without going back and,
Right.
just it's easier to ask sometimes. So you received a packet of information, and when you received this packet of information, I'm assuming you learned that you were a prospective juror in this particular case.
Correct.
Right? And obviously you had heard about the case before you received this, right?
Correct.
So when you learned that you were a prospective juror in this case,
Mm-hmm.
what was your initial reaction?
That I didn't really want to be involved.
Okay. And that's a fair and honest answer, and I appreciate that. Were you concerned about like physical safety? Was it COVID-19 stuff, or was it more just, I don't want to have anything to do with this because it's too high profile?
No, it has nothing to do with safety or COVID or anything like that. It's more what we were discussing a few minutes ago about the financial part, because I knew it would be a long trial and how I would work through that.
Sure. And maybe we can just skip some of my other general questions for a second, and let's talk about that, because maybe it's a short order type of a situation. Okay?
Got it.
So obviously we recognize that jury service is an inconvenience for all involved. And the question ultimately becomes, is it just an undue burden or hardship to you, right?
Mm-hmm.
Like, if you were to be selected as a juror on this case, would you be able to continue paying your mortgage or your bills?
Yes.
Okay. And do you think it would damage your business in a tremendous way? Because I know you said you're self-employed.
Yes. Possibly. It's my busy time of year right now.
Okay.
So it'll definitely affect me.
Right. And again, without saying the name of your company, because we are trying to protect your identity, you're in real estate, I believe?
Correct.
Real estate sales, home sales, and things of that nature?
Correct.
Coming into the spring, I think spring historically is a pretty big time of year for
Yes.
home sales. Obviously, the market is pretty red hot right now.
Yep.
So, is it simply, I don't mean to be glib about it, right? But is it the difference between I'm going to make some money or a whole lot of money, or is it I'm just going to make some money or no money?
Probably the first part.
Okay. So, So it wouldn't. It would be an inconvenience, but not necessarily an undue burden. Is that fair?
Correct, yes, that would work.
I'm going to go back to with all due respect, I don't think you'll qualify as an undue hardship. So your concern was really just financial and business related. How did you feel when you came down to the government center this morning, or this afternoon, I should say, and kind of saw the fortifications and the environment around downtown right now?
Yeah, it was quite the scene, I guess. It's kind of what I expected.
Okay. You had heard something about these preparations, I assume?
Correct.
Okay. Did it cause you any concern?
No.
Did it make you feel safer?
Actually it did, yes.
Okay. And then when this afternoon, when we had that initial set of instructions, did you, and the judge was saying that we're doing everything we can to protect your anonymity, how did that make you feel?
Fine.
Okay.
I'm fine.
At some point, however, you understand your name may be released publicly. Does that give you any pause or concern?
No.
Okay. Let me ask you, generally speaking, in your personal or professional life, I suppose with 3 grown children, at some point in your life you have been called to resolve a conflict between 2 people.
Right.
Okay. Can you think when you've been confronted with that, can you think of how you approach that? What tools do you use to approach a conflict between 2 people, and how do you try to resolve it?
I'm not exactly sure what you're asking. I guess just try and mediate.
Okay. So I'll put it in a more specific example and less abstract. Let's assume one of your children came to you and said, Dad, this is what happened, and another one came and said, no, this is what happened. Right? There's a conflict inherent between those 2 stories. Agreed?
Okay.
How do you go through, what's the process you go through to determine which side is A, being truthful, and how do you resolve the conflict between your kids?
Right. I guess you just listen to both sides and talk to each one of them and go from there, I guess.
Okay. If you were a juror in this potential case, or you become a juror in this case, the ultimate goal of the juror is to resolve conflict. Agreed?
Agreed.
And there's obviously a very big conflict between the state of Minnesota and Mr. Chauvin, and there's a potential for conflict in the jury room amongst the potential jurors, right?
Yeah, right.
So taking the hypothetical situation into the jury room, right? One group of jurors has a perspective about a piece of evidence, and a different group of jurors, they don't agree.
Right.
You're kind of in the middle. Let's put you in the middle at this point. How do you reconcile, or what tools would you bring to the table to reconcile that type of a dispute?
I don't know. I guess that's what I just said. Just listen to both sides and kind of see what side I fall on and go with that.
Okay. And so do you think it's like a situation where perhaps there may be other information that would assist in the analysis of whatever that is?
Right.
Or what other people might have to say about that same perspective?
Yeah, that's correct.
I don't want to put words in your mouth.
No, it sounds like a reasonable way.
And I guess the question is are you the type of person that's just going to agree with one side to build consensus and get this over with and be done? Or if you have a personal feeling that's strong, are you going to dig your heels in and stand your ground?
No, I'm pretty good at standing my ground if I feel a certain way.
Okay. And do you think you could do that if, let's assume there's this one piece of information. This is the critical key as you see it. And the 11 other people are telling you you're wrong. Do you think you could withstand that type of pressure?
I think I could.
Are you at the same time willing to re-examine your beliefs or your views about that piece of information?
Yeah, definitely.
Okay. Can you think of a situation in your life where you've been 100% certain that you are right, only to later learn you're wrong?
I would have to think about that, but not right off the top of my head.
Okay. Can you imagine? I liked the example one person gave of being 100% convinced that an athlete has a particular statistic. You look it up, and it turns out you're wrong.
Right.
And that's a very basic kind of an analogy, right? Is anything like that you think ever happened to you in your life? Or can you picture something like that happening?
I can't think of anything right now.
Okay. Well, let's assume that you were 100% convinced of something, and then someone presents you with this evidence that you're wrong. Are you the type of person that goes, oh, well, big deal? Or are you the type of person that looks at it and goes, well, I need to apply this in some other situation?
Yeah, I mean, if I find out I'm absolutely wrong, then yes, I could deal with it.
Okay. Your job as a potential juror in this case is to be the judge of the facts. What happens? What happened? And ultimately, at the end of the case, you will be asked, or you'll be provided with the law that the judge says is the law in this case. Can you apply the law even if you disagree with it or think that the law should change?
Yes.
All right. So I'm going to follow up with some questions about your answers. The questioner asks you about what you knew about the case before you filled it out, right?
Correct.
And you wrote, I've seen a couple of videos from different angles with Chauvin's knee on Floyd. I've heard one of the officers was recently new to the force, don't recall which one. And that's what you wrote. So I guess the question I have is, in terms of the videos in this case, you have seen some various videos about what happened in this incident?
Right. I have not seen a full video. I've seen pieces of various ones.
Okay. So that's what I want to make sure we're talking about the same videos and which videos we're talking about. So you understand that a bystander took a video. That video ultimately went viral on social media and became a news story.
Right.
Have you seen that video?
Yes.
And when you say you've seen that video, did you go onto the internet and download the whole video, or are you talking about clips you've seen in various news sources?
I've seen clips. I have not seen the full video.
Now, I am aware that some other videos have gone into the public sphere, and there were like body-worn cameras from officers. There were some security or store surveillance videos. Have you seen clips or the entirety of any of those videos?
I don't recall seeing any of those.
Okay. So I guess the question is different angles. Were there other, I guess, bystander videos that you saw?
No, I can only think of one, and it's probably the main one that gets shown or has been shown all the time.
Okay. And you indicated that you had seen, based on your best estimate, some or all of that video, well, parts of that video, I guess we should clarify, 4 to 5 times?
Right.
Okay. And maybe some still images that were taken from that video?
Correct.
Okay. You were asked about your general impression of Mr. Chauvin and Mr. Floyd, and with respect to both, you had a somewhat negative, I guess, general impression of both Mr. Floyd and Mr. Chauvin, right?
That's correct.
Okay. And I just have to follow up. With respect to Mr. Chauvin, you wrote, I've only heard about Chauvin's reputation. What have you heard about his reputation?
I'm trying to recall here. I don't know, that he was kind of a hard ass.
Okay. All right. That maybe there was a reputation of some past incidents.
I already worked at a bar.
Okay. And then with respect to Mr. Floyd, you wrote, I've heard some things about his past. What did you heard about Mr. Floyd's past?
Just drug use.
Okay. Now, you understand if you were to be selected as a juror in this case, would have to judge this case based on the evidence in that's presented in the courtroom. Do you understand that?
Yep.
Okay. And you may have heard some things about Mr. Chauvin's past or Mr. Floyd's past, and that information may or may not come into this trial. Do you understand that?
Yes.
So could you, if you were a juror in this case, the question ultimately becomes, anything you've heard before, can you set that aside and kind of start from zero, right? And judge this case impartially, fairly, on the evidence as it's presented in court?
I definitely can.
You were asked a question about whether you have talked about Mr. Floyd's death with friends, family, coworkers, etc. And you checked that you had, and you wrote, the media seems to try influencing viewers one way or the other. So your perception, correct me if I'm wrong, as I understand this, is that regardless of which position you may take, the media is going to try to bias you one way or another? Is that?
That's the way I feel, yeah. I'm not big on the news.
Okay. So, and you don't watch much news?
No, just weather and sports is about all I tune into.
Okay, fair enough. You were asked a question, do you believe your community has been negatively or positively affected by any of the protests that have taken place in the Twin Cities area since George Floyd's death? And you wrote negatively. Can you explain that?
Well, I guess my community where I live and hang out in probably hasn't, but the Minneapolis community, I'm sure.
Okay. So would you agree there's a difference between protests and riots?
Yes.
Okay. Well, how would you describe the difference between the two?
I don't know. It seems pretty self-explanatory, I guess.
Okay.
I'm not big into protests either. I've never participated in one. I never plan on one. I just think riots, I don't get that either, when people destroy their own city.
Okay.
Maybe you could pull up just a little bit.
All right.
So I think what you're saying is that the rioting was negative for the city of Minneapolis, but the protests you just don't really care about?
Exactly right.
Okay. You indicated that you have a couple of friends or clients that are police officers in various cities. Are any of them Minneapolis police officers?
No.
Okay. If you were a juror on this case, the subject of police training may become an issue in terms of the use of force, right? We're going to call up your friends or your clients and say, hey, is this how you guys are trained in X city?
No.
Okay. All right. There's a question, and I just want to remind you, you have the right to request a private hearing, but there's a question about being a victim of a crime or being arrested for a crime. Are you comfortable answering those questions here?
I am without audio.
Without audio? Okay.
I think I know which questions, because you did mark one specifically to be answered privately. And so I am going to find under the rule that this would involve particularly sensitive material, so I'm going to order the audio to be not broadcast, and so that'll be turned off.
Thank you. All right. On the questionnaire, sir, there were a series of questions where you were asked to rank your opinion, so to speak. There were these statements, and you had to rank your opinion from a 1 being strongly agree to a 5 being strongly disagree.
Okay.
And I just want to follow up on a couple of those statements. One of the questions you were asked was, blacks and other minorities do not receive equal treatment as whites in the criminal justice system, and you somewhat agreed with that. Can you answer why you somewhat agreed with that statement?
Well, again, it's just something I've seen on the media.
Okay. Do you have
That's going off that, and again, I don't watch that much.
Okay. I mean, do you have any personal experience that would lead you to that conclusion?
No, I don't.
Or any friends who have said, hey, you're not going to believe what happened to me?
Right, no.
Okay. You were asked, or the statement reads, police in my community make me feel safe, and you somewhat agreed with that. Do you have concerns about policing or that they're overly aggressive, anything of that nature?
No, I really don't have an opinion on that, I guess. I just...
You don't disagree with it?
Right.
Okay.
I guess I wouldn't know.
Okay. I mean, police in your neighborhood, they patrol your neighborhood, they take care of the neighborhood, and you don't know if they'd make you feel safe or not?
Well, I kind of live, it's hard, I don't really want to say, but not in a neighborhood.
Okay, gotcha. And you were asked the statement reads, I do not trust the police, and you somewhat disagreed. Is that kind of the same analysis?
Yes.
Okay. You were asked the question, I support defunding the Minneapolis Police Department, and I think that's where you only strongly disagreed with that, right?
Correct.
Okay. All right. You were asked a couple of questions about both Black Lives Matter and Blue Lives Matter. You checked neutral. You have a neutral opinion of both statements, and there was no answer. I mean, do you have any particular perspectives to share?
Yeah, I really don't have any opinion on either of them. I don't pay that much attention.
And so, sir, just want to make sure that because you did check, the question was asked, do you want to serve as a juror in this case? You checked not sure, and you said, why do you feel that way about serving as a juror? And you said the length of time. Right? But it would be fair to say, I think we've already covered, you can make it work, right?
Yeah.
Yeah, begrudgingly, I understand.
Right.
Okay. If I may have a few moments here. Yeah. We'll pass for cause, Your Honor.
Mr. Slusher.
Thank you, Your Honor.
Juror number 73. I wanted to follow up on some of the questions that you responded to regarding your employment, your self-employment, busy time of year.
Yep.
And the real estate market is pretty good right now.
Yes.
Okay. So if this does end up, if this trial ends up taking a little longer, and would you be surprised if I told you that attorneys are terrible at estimating how long things take?
Right.
Right. You know, I think that to be fair to both sides, we just need to be assured that if we're in a situation where the trial starts grinding on and maybe it's a little bit longer than you'd hoped, that you would be able to give your full 100% attention to the witnesses who are testifying and the evidence being presented. Would you be able to do that?
Definitely.
Okay. And then when the trial is over, when the government rests and there's deliberations, you know, those might take longer than you would hope as well. And, you know, to be fair to both sides, it's very important that you'd be able to commit, that you wouldn't be thinking about the business you're missing, you'd be thinking about what you need to do to reach a verdict in the case.
Right. Yes.
And did you say definitely?
Definitely, yes.
Okay. Thank you. You indicated that your somewhat negative impression of the defendant, of Mr. Chauvin, was based on his reputation.
Reputation, from what I've heard, correct.
And what specifically have you heard? I heard you use the term hard ass, but have you heard anything more specific than that?
No, I really have. Just he worked at a bar and he had an issue with Mr. Floyd, I've heard. I don't know.
When you say he had an issue with Mr. Floyd, do you mean at the bar?
I think so. I don't know.
Okay. And I'm curious as to the source of your information. Was it media? Was it someone who purported to have firsthand knowledge?
No, I'm sure it was media.
And probably just more directly, you've indicated that you have some friends who are law enforcement officers.
Correct.
Was it any of your friends who shared their opinion of Mr. Chauvin's reputation with you?
No.
So it would have been purely a media.
Right.
Okay. How many different law enforcement officer friends, and I want to divide the friends versus clients, because you've mentioned both. I'm assuming you have a lot of clients.
Right. One is probably one of my best friends, and the other two were clients. Basically, just stay in touch with once in a while.
So let's talk about the clients first.
Mm-hmm.
You said they were clients.
Past clients, correct.
Okay.
That I'm still in contact with. I stay in touch with my people.
Sure. But of course, changing houses isn't like changing cars. You know, there's not nearly as much turnover.
Right.
And so I'm wondering, just in terms of your current, financial relationship or business relationship with these individuals, they're past clients. You don't have a pending sale with a law enforcement officer?
No.
Okay.
Not at this time.
Okay. So let's talk about the other officer. You say you have one law enforcement officer who's one of your best friends.
Correct.
And you said that this person does not work in the city of Minneapolis, or for the city of Minneapolis.
Correct.
Is it a large department or a small department?
I would say it's large.
In the 7-county metro area?
Yes.
Okay. How long have you been friends with this person?
I first met him as a client about 20-some years ago, and then we just became friends.
Okay. Approximately how often do you see or talk to this person?
I talk to him probably once a week.
Once a week.
Mm-hmm.
Do you go over to his house?
No, it's usually phone.
By phone?
Yeah.
Okay. Have you and your friend talked about this case at all?
No.
Your friend has never shared with you any opinion that he or she has about this case? Is it a he or she?
It's a he.
It's a
no.
he. Okay. What about sort of law enforcement in general? Has your friend talked to you about policing, what that's like?
No, I haven't in years, but I've gone on ride-alongs with him.
You have?
Mm.
About how many times?
At least twice.
Day shift, night shift?
At that time, it was night shift.
What did you think of that experience?
It was interesting. I saw some things.
Yeah? What did you see?
I saw a guy had fallen off his deck and split his head open. Saw that. Saw DUI arrests. Saw someone that had passed.
Sounds like you saw a lot in just a night.
It's a bigger city.
Yeah. What do you think of that as a career path? The job your friend has.
Yeah. It's not for me. Stressful, I'm guessing.
Okay. Can be dangerous.
Dangerous, definitely.
Your friend then, during the course of their shift, they have to exercise judgment, right? And exercise discretion. What are your views on, kind of questioning the discretion that an officer exercises in the field?
Well, from what I've experienced with them 2 times or 3 times whenever I was out, I didn't see anything. Nothing caught me off guard, like, wow, can't believe they're doing that or whatnot.
But I guess what I'm asking you is, in terms of other people questioning an officer's discretion, they have to make decisions, right?
Right.
And sometimes they make decisions, and it could look bad to someone. What do you think about someone who maybe doesn't have the same level of training as a law enforcement officer exercising judgment over the decisions they make?
Right, I get it. They probably don't understand the way things are done and the way they're trained, that kind of stuff.
Do you think that's fair? That someone would?
No, I don't think it's fair.
Has your friend ever expressed to you any concern about kind of the public opinion of police officers in the last year or so? How that's
a little bit, yeah.
Tell me about
just the way things are going these days. I don't really have any conversations that I can recall. I just remember him saying it's a little different out there than when he first started.
How so?
Just the way things are handled with the media, and everybody has a phone with cameras on it now, and so I just think things are more noticeable these days.
Maybe, literally more under the lens.
Right.
People can take out a phone and record you.
Yep.
And was that a positive or negative reaction that he was expressing to?
I don't think it was either. I think he was just expressing that things are have evolved, I guess, over the years, and they have to be more careful on how they act and say and that kind of stuff.
Time is not presenting. Can we sidebar just a schedule?
Yes, Your Honor.
Scheduling question.
I'm the law enforcement officer about how attitudes have changed. Things are a little bit different now in policing, and they have to be generally more careful. Is that right?
Right.
You're talking about that in the context of cell phone cameras. What about body-worn cameras? Does the department that you're friends with use body-worn cameras?
Yeah, I was saying they have more tools as well besides the general public.
Did your friend express any opinion, positive or negative, about using body-worn cameras?
No, I don't. We never talk about that.
So I want you to imagine a situation in which you were selected as a juror on this case, and you had to listen to testimony of law enforcement officers and also of bystanders. And these people that have been seeing the same thing, same events. Do you believe that you would credit the testimony of a law enforcement officer a little bit more than, say, a bystander?
Oh, I don't know. That's a tough question. I guess I would have to see what the. I don't know. I guess I don't know.
And that's kind of hard to think about that in the abstract. But just imagine you're hearing testimony. One person wears the uniform and has the training, and the other person is just simply a bystander on the street. Just knowing yourself as you do, what do you think?
Yeah, well, naturally, I probably believe the police officer more.
And why do you think that is?
Probably because they have more experience and they're trained to deal with whatever's going on, rather than the person walking down the street and all of a sudden seeing something happen.
Fair enough. Do you think that, part of your opinion that you might believe a law enforcement officer over that of a bystander could be informed by the relationship you have with your friend?
Maybe. I don't know.
And perhaps some of the experiences that you've had, doing the ride-alongs.
Right. Yeah, possibly.
I'd also like you to just imagine if you're selected as a juror and rendering a verdict of guilty. And then going back and having conversations with your friend. Do you feel that you'd need to maybe explain yourself to your friend?
No, I don't think so.
Well, why not?
Well, I mean, we've known each other 20 years or whatever it's been. I don't think he's going to have a say. I don't think it'd be an issue.
And regardless of whether your friend would, have a say or be an issue, I also want you to just really think about, in the deliberation process, would you yourself think to what am I going to say to my friend? How would I explain to my friend that I returned a verdict of guilty in this particular case?
I would just say that he wasn't there. He didn't see the evidence. He didn't see the people talking.
And that's how you'd explain it to your friend. I guess I'm wondering if would that be on your mind as you're listening to the evidence, as you're deliberating with other jurors. Would in the back of your mind you be thinking about your friend?
Yeah, I get it. Yeah, probably. I don't think I would be thinking about that.
You'd be able to put him out of your mind and judge the case based on the facts and the evidence?
Oh, definitely, yeah.
One moment, Your Honor. Thank you, Your Honor. And sir, if just in your own words, getting back to the financial issues, just in your own words, can you tell us what impact serving on a jury in this case, if the case went, say, 4 to 5 weeks,
right?
What would the impact be on you financially?
It would be I don't want to say devastating, but it would hurt.
Okay. And do you think that you would have to, like, so for example, go into savings to pay bills?
No. I mean, I'm just in real estate. It's down the road stuff, so I'd be missing a lot of stuff. So it'd be down the road. I wouldn't be getting.
I see. So participating as a juror now, that might cause you a financial hardship later.
This year.
Can you give us any sort of idea as to the true impact of that? It's not so much that you then would be concerned about the financial impact at the time, but what I want to know is if you can just estimate for us what type of financial impact that you believe it would have for you.
You want to know an amount about it, or what do you?
Not in so much of an amount. It's more like, are you going to be able to pay your mortgage, pay your bills, support your family?
I'll be fine.
Okay. All right. Right. Your Honor, need to make a record?
Sure. Sir, I'm going to turn it back to Mr. Nelson for a few questions.
All right.
Just a few follow-up questions on your the relationship with your friend who's a police officer and the testimony of police officers. What we heard you say is that if there are two people who are observing the same situation, one of them is a police officer and one of them is a civilian, would you treat those two people equally in terms of whether they should be determined to be credible, or would you automatically assume that the police officer is telling the truth simply by virtue of the fact he's wearing a badge?
Right. I would try to treat them as equal. Okay. It depends on who the other person was, and I guess what the circumstances they're talking about are.
Right.
But yeah, I think you tend to trust an officer more than just somebody in the general public.
Right. So let's assume again that one is a police officer and one is a reputable, law-abiding, normal citizen, right? And they're both looking at the same situation. Can you assess the credibility of both at the same level?
I think I would hope I could, yes.
Okay. And would you agree that circumstances may dictate, if it's a question of, say, a use of force or some other aspect that's particular to policing, you may credit a police officer more than a civilian?
Correct.
Okay. But all things being equal, if we're talking about is the sky blue, and one person says it's blue and another says it's green, would you simply believe the police officer because he's a police officer?
No.
Okay. Are you able to look at all of the other evidence, analyze it, a police officer's testimony in the same light as any other civilian?
I am.
I have no further questions.
Mr. Slusher, did you want
to ask anything further? Okay. Okay, let me just ask one question, sir. Credibility. Let's talk first about whether someone is more likely to tell the truth or not. Do you think that police officers are more likely to tell the truth than a civilian? If that's all you know?
Yeah, I don't know. That's a good question. I don't know. I guess more likely the police officer.
Okay.
But I guess it just depends on the situation.
All right. But do you think that police officers are inherently more honest, for example? More likely to tell the truth than not lie?
I believe so.
Okay. I'm going to grant the state's motion under Logan. Sir, you are excused from this jury panel, and so we won't dig into your business for this month.
All right. Thank
So
you.
thank you for your service and your answers to the
Thank
questions.
you.
Anything else to make a record of after this jury is done? Other topics?
Not on the record, Your Honor.
Okay.
If we have just a brief chambers meeting for today to talk about some other unrelated matters.
Sure. Let's kind of quickly go over. Mr. Schaefer has sent, I think, the jurors, but we're going to bring in 5 and 4, including the one from today, so we don't have to worry about waiting for everybody to go through the orientation video. That person has already, so we can start right at 9:30. 8:45, we'll do the Zoom hearing with the first 7 jurors who are seated to talk about their exposure to the settlement agreement. And Thursday, I plan on ruling on the May 6th, 2019 incident. Probably won't be a written order by then, but I think will be eventually incorporated into a written order as far as the court's analysis. That's kind of where we're at. So tomorrow 8:45, and I think Thursday at 8:45. All right. Anything else for the record before we have a chambers conference?
Not on the record, thank you.
Mr. Nelson, anything for the defense?
No, Your Honor.
All right. 8:45 tomorrow. Thank you all. We're in recess.